Good morning. Good morning. Good morning. Good morning. Good morning. Hey sis, how are you? So I just got out of another live stream. I knew this was obviously happening. Hey Erica, good morning. Hi Lisa, Penelope, good morning. Hey Erica. Okay, this is the deal. I'm gonna let you guys choose. Now, this is just listen to the sound quality.
Good
This
morning,
is
members of the jury.
This is the judge's Zoom that she's broadcasting on YouTube. Okay. I think the sound quality is better. You're just not going to see in the courtroom and you can hear the prosecutor. And we get the visuals of their slideshow. Okay. Just listen and I'm going to let y'all hear this audio. And then you guys, let me just get the right spot so I know where to come back so we can listen to it from the beginning.
All the evidence is closed, and we're now getting ready to hear closing arguments of the parties. I'm going to remind you again that statements made by attorneys are not evidence, and you'll rely on your memories as to what the evidence is. There are going
Okay, so you're the judge because she's clearly at her desk, right? Listen to Abadi.
On July 4th of 2020. That's what this case is about. That's why we're here. That's why when she was talking to of innocence, I like to kind of compare it to a cloak or a jacket. In photographs, I'm going to tell you that every party took things. It was a great experience.
Okay, you hear the sound quality? Let's go over here. I'm gonna let y'all choose which one y'all want to watch, okay?
between the arguments. You need a break, you can just let me know. I'll check in with you again because the arguments can be long. And we're planning to provide lunch for you today to try to keep things moving. Okay.
And the decision she wanted to go study. We learned all of those things from her mother as she sat before each and every one of you and told her first duty. And your duty is just plain and simple. And this indictment. Now, as I'm saying,
So you're not going to be able to see the presentation and the sound quality is
for you, ladies and gentlemen, to determine.
trash.
Your determination identity is dependent upon the credibility of.
Okay, this is the other option. You're not going to see, you're going to see the slideshow and you're going to be able to hear.
Exactly what you're going to have to do when you're looking at the facts of the testimony of this case. The judge is also going to tell you that the testimony of a single witness, if believed, is sufficient to establish the fact.
Okay. I thought that's what you guys would say because it's the quality is very bad. I mean, it's we know what a body looks like. It's more important that we hear the information rather than yes. Hey Apostle, good morning. Good morning. Good morning. Good morning. Good morning. Okay. It's more important that we hear what's going on. Yeah, because this is like the view. It's basically like if you guys see over here how they have those cameras in the courtroom over here. You know how she's got those big cameras over her desk? That's probably the filming for these wide angle shots on her desk where you can kind of see the teams and you can see what's going on in the courtroom, all of that. I wish we would have known that this was up, but one of our bougie gang told us about it yesterday, so I'm glad we have it now. But yeah, let's get into it. We'll be able to see the presentation. So, all right, let's hear.
Okay.
Okay, I just want to make sure you guys were good with that.
Can be long. And we're planning to provide lunch for you today to try to keep things moving. Okay.
Oops.
The trusty old technology to work. I want to start by talking to you about this case. Not about this case. Not about the actions of Charmaine Turner on July.
If anyone comes in and is like, where's the video? Why isn't showing like whatever? Can you just handle that for me, guys? We're just looking at a different view because the Fox view, thank God for options, right? Because we could just be stuck with that, but there's a better option with better sound, and it's more important that we hear what's going on rather than see somebody walking around the courtroom. Not to mention, we can see the presentation as well. So just handle that for me in the comments, please.
2020. Not about money. This case is not about the decisions that Omar Ivory was forced to make. It's not about the man behind the wheel. And ladies and gentlemen, this case is not about 2 + 2, 4 + 4. It's not about that. It's not about the mother and behind the wheel or math. Ladies and gentlemen, this case is about the intentional and deliberate and conscious decision that this defendant made if he wielded his AR-15 on a public road in your county, ladies and gentlemen, on July 4th of 2020. That's what this case is about. That's why we're here. We are here because of what he did on July 4th, 2020. What he did to an 8-year-old little girl. What he did to 8-year-old Sequoia Rivera. The day that he ended her short 8 years of life. What we did learn during the course of this trial, we learned that Sequoia loved to dance. We learned that Sequoia loved to read. We learned that Sequoia loved to learn. And she already made a decision she wanted to go to Spell. We learned all of those things from her mother as she sat before each and every one of you and told her about the absolute worst moments of her life. She told you and sat here and explained in great detail every parent's worst nightmare. The most unnatural thing in life. She sat before each and every one of you and explained to you all the facts and circumstances that she experienced in that absolutely terrible moment in her life. As she sat before each and every one of you last week. When Charmaine was testifying, she talked to you about how much Sequoia loved her brothers. She loved playing with her cousins. And she said something while she was testifying that caught my attention that I'll never forget. She said she just loved to love. She just loved to love. And this defendant on July 4th took that love away from this world, took that love away from Charmaine. But as she testified, she talked to you about the last moments of Sequoia's life. And I hadn't caught it, I hadn't heard it until she sat before all of us and explained to each and every one of us what she felt, what she remembered, and what happened in that car on July 4th, 2020. But when she was testifying and when she was talking to each and every one of you about the last moments of little Sequoia's life, she said she didn't talk. She just looked into her mother's eyes. She just caught her eyes and gazed into her mother's eyes. In the last moments of her life, Charmaine was describing Sequoia still trying to provide that love, that comfort to her mother. And this defendant on July 4th of 2020 shut that light off. Made it so the joy that Sequoia's family felt every single moment that they were around her was gone. But Charmaine made very clear that Sequoia's memory will live on. That they created a scholarship at Spelman in her name. And that he may have taken her from this world, but he can't take her memory. Her light will always shine on the things that were most important to her. And that was clear from the testimony of Charmaine. That was her family. Now, I want to talk to you over the next 25, 30 minutes about some of the law that the judge is going to explain to you at the end of the trial. And the law that you're going to apply, all the facts and all the evidence that you've heard this week, and feels like more than a week ago. Can we say for me? But I want to start with talking to you about your duty, a juror's duty. And your duty is just plain and simple. Be a fair, impartial juror, honestly seeking the truth. You're not to seek doubt. You're here to weigh the facts, weigh the evidence, and make a decision. It's kind of what we talked to you when we started the process. It's exactly what we did. We asked you questions, you gave us answers. We asked you some more prying questions, and you gave us answers. And that's how we were able to determine that you, ladies and gentlemen, were the right people for this job. That you could listen to all the facts, that you could listen to all the evidence, and be fair and impartial, and seek the truth of what happened on July 4th of 2020, when Sequoia Turner was killed. Now, again, to seek the truth, you're to follow the law that the judge is going to give to you, and you're to deliberate. And we say that, the deliberate part, I know it sounds incredibly obvious, but there have been times in the past where jurors forget that they're supposed to deliberate, and one or two may decide that they don't want to partake in the proceedings. Let me just tell you that so you're aware that that does happen, and I don't think it will, but if it ever does, that's something you just bring to the court's attention, and it'll be addressed. You're to seek the truth according to the evidence. You are to determine the facts of the case based on what was presented to you over the course of the last 2 weeks. All of the evidence in the form of photographs, videos, testimony that you've heard from the witnesses here at this witness stand, and up in the courtroom, it sounds like the bigger jury room, that first day that we started a trial. Now, what you're not to consider, you're not to consider passion. You're not to consider public opinion, whether you are unhappy or like the performance of the police here or in your past. Public feeling and sentiment as it relates to social issues that we've heard a little bit about over the last 2 weeks. Sympathy for the defendant, sympathy for Sequoia's family. Whether you disagree with the law, conjecture. You are not to consider penalty or punishment. That's for the judge. And any prejudice you may have. You leave that outside of the deliberation room. And what you are to consider, and what you are to use as tools to apply the evidence and the facts and the testimony that you heard is obviously the law, the testimony of all the witnesses that you heard and your recollection and reviewing your notes, admitted evidence that you will receive at the end of this trial, the elements of the crime, which you'll learn about here shortly from the parties and from the judge, expert witness testimony, physical evidence, and as we all talked about on Monday, 2 weeks ago, your common sense and your life experience. You use all of that when you are cycling through and remembering and looking through your notes about the facts and the evidence and the testimony that's come out over the course of this trial. Now, you heard a little bit about this at the beginning of the trial, about whether you can hold the state to this burden of proof. And that burden of proof, it rests with the state. It never leaves the table. The burden of proof is always with this side. The burden is for the state to prove beyond a reasonable doubt each and every material allegation, each and every element of every crime in the indictment that you painstakingly heard me read the first day we started the trial. Now, the judge is going to talk to you about each and every defendant. This defendant, when we started this trial, had a presumption of innocence. Every defendant who exercises his constitutional right to a trial has this presumption of innocence. I like to kind of compare it to a cloak or a jacket. So he walked in on the day we started trial with a suit coat on, with the presumption of innocence, and as the facts, testimony unfolded, as witnesses testified, as the video from every angle was shown to Detective Shepard, started getting warmer in this room, and it was pretty warm throughout this trial. But as the evidence, and the facts, and the testimony continued to come out, that cloak came off. That cloak of innocence went goodbye. Because the state proved, well, we rested beyond a reasonable doubt that this defendant is guilty of each and every count in this indictment. Now, you're going to hear a lot about reasonable doubt, what it means, and a bunch of lawyer jargon. We lawyers tend to use words that should be easy to understand, then we take them and garble them and make it pretty complicated. So reasonable doubt means just what it says, reasonable. It's based on your common sense, your reason, your life experience. It doesn't mean an arbitrary or vague doubt. It's a doubt in which you can give a reason. It's a doubt in which it's reasonable. Now, the state's not required to prove the guilt of the defendant beyond all doubt, beyond a mathematical certainty. There's no equation involved, because the only equation that's involved in this trial, any way that you put it, if you do 2 plus 2, 4 plus 4, whatever it may be, they all equal -1. They all equal -1, because no matter how you look at it, how you put the facts, circumstances together, Corey's gone. He's not coming back. That's the equation that's important in this trial. Reasonable doubt is the doubt of a fair-minded, impartial juror honestly seeking the truth. Again, you're not to seek doubt. What does that mean? Apply your life experiences, apply your common sense to what you heard over the last 2 weeks, and that's how you come to your decision. That's what you do back in the deliberation room. The only difference is once the trial ends, once the judge finishes the charge, you guys are in the driver's seat. You don't have to wait on us. There's no breaks because of any conversations that the attorneys have to have, or any sidebars with the judge. You guys are in control, and you guys get to apply all of your life experiences to everything you've heard over the course of this trial. The judge is going to talk to you about the different kinds of evidence. There's direct and circumstantial evidence, and she's going to explain to you what each one of those is. It's fairly obvious. Direct evidence is evidence that points immediately to a question at issue. So it's evidence that's tangible. It's photographs. It's the videos. It's documents. It's testimony that you heard from witnesses as to what they saw, what they heard, what they remembered seeing and hearing on July 4th of 2020. She's also going to talk to you about circumstantial evidence, but as it relates to direct evidence, again, not the 911 calls that you heard, things of that nature. What Omar and Ms. Charmaine recall, how they were able to remember and talk to you about the 911 call that was made that night, and the people they remember seeing surrounding them as they passed the barricades. Circumstantial evidence is proof of facts or circumstances by direct evidence, which you infer other related or connected facts that are reasonable and justified, again, in light of your life experience. Now, I like to provide an example. I think we all experienced in life an everyday experience. So when I'm one of 4 children, twin sister, I have a brother who is 16 months younger than me, and I have a brother who was 6 years younger than me. So my mom had her hands full throughout the years that she was raising us. Now, before my youngest brother was born, it was almost as if my sister, my brother, and myself were triplets, because we were very close in age, and we were pretty wild. So we injured ourselves quite often. And so we were either in the ER, doctor's office, whatever it may be, with a broken arm, busted leg, busted lip, something that needed to be patched up. Now, if you use what we just talked about, direct and circumstantial evidence, circumstantially, you don't know anything about facts and circumstances. You see my mom bringing all 3 of her children to the hospital with the doctors injured, and you may draw some inferences based on what you just see, not knowing any of the context or the details. Now, what's interesting is as the doctors would speak to each one of us children, as they would treat each one of our injuries, what they were able to see directly from speaking to us, the injured parties, and my mom, who unfortunately for her was an eyewitness to most of our injuries, was that we were crazy 3 kids who couldn't sit still and liked to have fun. And so that's how I like to explain direct and circumstantial evidence and how you apply it and use it. And what the doctors would say beyond a reasonable doubt, after we leave, after each visit, that we be back. And that my mom has the patience of saying. So that's how you use your life experiences to, use direct evidence and circumstantial evidence to come to a conclusion, like exactly what you're going to have to do when you're looking at the facts and the testimony of this case. The judge is also going to tell you that the testimony of a single witness, if believed, is sufficient to establish a fact. Generally, there's no legal requirement for corroboration of a witness, provided you find the evidence to be sufficient. Who's a great example of this? You heard from Mr. Christopher before. He testified about his experiences in the community, how long he lived in that area, prior and university, and his experience on July 4th, when he approached the barricade, and what he remembered, and how he remembered that 2 people specifically, one had a shotgun, another had a long rifle, pointed it in his face to him and his wife as they attempted to pass through. They were able to turn around after Mr. McCord had an exchange of words with the later identified as the defendant, Detective Shepard, when he told Detective Shepard that the individual he saw on the news conference was the person who pointed that AR-style rifle at his face when he first encountered the barricades. And Mr. McCord's testimony, Mr. McCord's recollection is further corroborated by the video evidence that you saw painstakingly over and over and over again over the course of this trial. You see this defendant in his very distinctive clothes with his AR-style rifle doing some sort of look like military move, pointing a weapon in the direction of both Mr. and Mrs. McCord, looking as if he's about to engage their vehicle with his AR-15. You are also going to hear about how you're to judge the credibility of witnesses like Mr. McCord, how you're to judge the credibility of Detective Shepard, and how Detective Shepard explained to you the process in which he took and how he worked backwards after he got all of the video tracking the defendant because of his distinct clothing in each one of the videos and each one of the angles in order to place him exactly where he told you and where this defendant is at the time that the Chief Secoria is traveling in past the barricade, at the time that Secoria is shot in the back. The judge is also going to talk to you about statements that you've heard previously. It's not a secret. This case is not a case that occurred yesterday. It's a case that occurred in July of 2020. As your common sense will tell you, memories fade. That's why things are reported and things of that nature. That's why you've heard about reports and prior statements that were made and talked about for the testimony of this case. Now, the judge is often going to talk to you about identification. And identity is a question of fact for you, ladies and gentlemen, to determine. Your determination of identity is dependent upon the credibility of witnesses or witnesses offered for this purpose. You should consider all the factors previously charged about credibility, which you'll hear about again from the judge at the end of the trial, and the factors you would apply and the ones we just talked about. And a great way to kind of boil this down is the books when we were kids, the Where's Waldo book. And at first you flip through each page, you look for wherever Waldo was, but once you found him, you never couldn't find him again. That's exactly what we have here. And that's exactly what Detective Shepard explained to you. And that's exactly what you saw as it relates to this defendant's distinctive clothing And once you know where he is, what he's by, and when he's at the barricade, you can then use those contextual clues that you've learned from your previous experience of seeing where this defendant is, what he's wearing, and how he looks. And then you never lose him. And that's exactly what Detective Shepard described. This is exactly who Detective Shepard first saw in the Martyr video. In photographs of during the day prior to being seen in the Martyr video, the exact same clothing, the exact same satchel, exact same gun, same photos, photo. The defendant's photo from his license. And the defendant, on the day that he did his press conference, and provided you the statements that he did along with his counsel that reference his recollection based on not knowing what was eventually found on the video. That statement was made by this defendant and his counsel before he knew there was more than bolo photos from a Martyr video. Before he knew that Detective Shepard had been able to pull video footage from the all package liquor store, that he was able to pull footage from the BP gas station, and that he was able to pull footage from the 2 cameras at the warehouse, and that he was able to track the defendant's every move as that car approached the barricade. So when he did this press conference, the distinctive outfit was nothing to him. It was just a gang advertisement for the pirate gangs. He didn't know that Detective Shepard was able to track that red shirt with its distinctive red lettering in each one of the cameras that he described to you. Now, I want to talk to you about parties to a crime. And we referenced aspects or parts of this during body or jury selection. I'm going to talk to you about this. And the judge is going to tell you that every party to a crime may be charged with, convicted of the commission of the crime. Person is a party to a crime only if that person directly commits the crime, intentionally helps the commission of the crime, intentionally advises, encourages, hires, counsels, or procures another to commit the crime. The judge is also going to tell you about, and you heard when we read the indictment, about Julian McKinney. And the reason this slide is up here, the reason this chart is given to you, is that you're not to consider Mr. McKinney and his case and what's going on with it. You just consider the evidence that you've heard and his role that he played and how he worked in conjunction with this defendant. That is that's what's important to your analysis, ladies and gentlemen. That's what is important as you view and go through the evidence and remember the testimony. It's the role that Mr. McKinney played and how he worked with this defendant. You're not to consider or worry about what's going on with his case. His case for another day and for another jury. Now, you also heard from Detective Shepard about parties to a crime. He gave you an example involving a bank robbery. And I'm sure each one of you remember the example he gave and how he gave it, and the importance it plays in providing an example as to basically the actions of one or the actions of all as you work together. And the way I like to think about it and describe is kind of a team sports example. My brother played football at Wake Forest back when the one season that they were pretty good. They done the Orange Bowl, and I went to every one of his games. It was a great experience to watch somebody who you care about succeed on such a high level. And why it's something that I am able to utilize when I'm talking to people like you, ladies and gentlemen, is because in a sport like football, it's every player has a role. You've got the quarterback, you've got the defense, the offense, things of that nature. And the matter the quarterback throws an 8-yard pass and a touchdown, occurs, 7 points go on the board. It's not 7 points for the quarterback. It's not 7 points for the person who caught it. It's 7 points for the team. Here was the team in defense. So everyone has to play a role in order for the end goal to occur. And when the end goal occurs or a failure occurs, the entire team accepts the goal or gets to succeed and celebrate or not, but together. It's not just the quarterback getting the 7 points or the running back getting the 7 points. It's the whole team, or it's the whole team losing. So everyone plays a role in order to get to the end process, in order to get to the win, or in order to incur the loss. The judge is also going to talk to you about conspiracy. It's very much kind of like parties to a crime. So conspiracy means an agreement between at least two people to commit an unlawful act. That agreement does not have to be something where you shake hands and verbal in nature. It can be shown through conduct and presence of the parties involved, the presence, companionship, and conduct before and after the commission of the alleged offense may be considered in your determining whether circumstances arrive to the point where you think a conspiracy exists. And what does that mean? It basically just means that the things that you do before, during, and after, the actions that people see, the fact that this defendant and the members of his gang and friends showed up to the barricades, worked in tandem as a team to prevent citizens like you, ladies and gentlemen, from traveling down University and Pryor. And at times when people didn't submit to that authority, when people asserted their own independence on July 4th, they were met with threats and they were met with violence. And Sequoia was met with the ultimate violence. She paid the ultimate price for the lack of submission to their authority. Like I said, the agreement may be expressed, meaning be written, things of that nature, but it also can be an unspoken understanding. It can be a group of people, as we heard yesterday, at times, all showed up for the same cause, all did similar, the same actions in the sense that they didn't have an agreement where they wrote down on a piece of paper, they were gonna not let people pass through the barricade, but the unspoken understanding was the fact that they all participated and didn't let people go through the barricades, and there were consequences that they all worked together to provide to individuals who didn't assert to their authority, to individuals who didn't submit to their confidence. What the evidence showed during the last 2 weeks was that this defendant and his other co-conspirators, named and unnamed, known and unknown, through their actions, their words, both had an agreement to participate in a legal barricade. When they did that, they refused to allow citizens to travel through the University and Pryor. And if anyone attempted to disrespect them, anyone attempted to travel through those barricades, they were met with violence. That's what we saw. That's what the defendant's actions are boiled down to on July 4th of 2020. How do we know there were 2 or more conspirators? You've got video evidence. You've got video evidence from angles everywhere. You've got 3, 4, 5 people at the barricade at times. You've got the defendant shooting with 3 of the people he had been guarding the barricade with through the evening of July 4th. You've got the examples of an agreement with the aggravated assault that was incurred on McCourt's. You've got McCourt's leaving. You've got 1, 2, Mr. McKinney, 3 individuals with guns, all working in tandem, all following, fleeing, of course, all an example of an agreement by 2 or more conspirators. What the agreement does not require, as we talked about, written or it doesn't have to be written or oral, it doesn't have to be anything that necessarily has to be said. To write a contract with details, it can just be an understood thing where, like this situation, you stand at a barricade with your AR and you don't let people through, and you commit acts of violence when they don't submit. But the judge is going to talk to you about, and you're going to hear about the elements of all the crimes that you heard in the indictment that were read to you at the beginning of this trial. She's going to talk to you about count 1, murder. She's going to talk to you about count 2 and 3, which are felony murders. And the predicate offenses are acts for each one of those felony murders, that being the aggravated assault with a deadly weapon on Sequoia Turner. And then count 7, which is the criminal damage to property in first degree from the shooting of the Jeep that Sequoia was riding in when she was killed. You're going to hear about the aggravated assaults, counts 5 and 6, that Omar Ivory and Charmaine Turner's experience when their car was fired on, the same car they were traveling with a little Sequoia. You're going to hear about count 8, possession of a firearm during the commission of a felony. You're going to hear about counts 9, 10, 11, and 12, and then 17, 18, 19, and 20 about those specific charges involving participation in criminal street gang activity, the different subsections that the judge will read and tell you the elements as it relates to each one of those charges. Then you're going to hear about counts 13 and 14, which we talked a little bit about today, about the aggravated assault that McCord's experienced when they first encountered the barricade with guns being pointed and threatened because of the disrespect they were showing for beginning to travel through the barricade. And then the aggravated assaults that you actually saw that were committed on the video by this defendant and Jeremy McKinney when they were pointing their firearms at both Mr. and Mrs. McCord as they drove away. And the judge is going to tell you that with every one of the crimes in this indictment, specifically murder, intent is an essential element of any crime that must be proved by the state beyond a reasonable doubt. You may be shown in many ways provided before you, ladies and gentlemen, by facts and evidence from the witness stand, from physical pieces of evidence that are entered during the course of the trial from different witnesses, and you may infer from the proven circumstances or by acts and conducts, or it may be in your discretion infer when it's the natural and necessary consequence of the act. So what does that mean? The natural and necessary consequence of pointing your AR style rifle and pulling the trigger at least 8 times as a car, just in this instance, a Jeep, where Sequoia was seated in the back, just playing on her phone, watching TikTok. And when you fire that weapon, that high velocity rifle into that vehicle, the natural and necessary consequence, it's going to hit somebody. It's going to hit the driver. In this instance, it could hit Charmaine. And in this instance, it did hit Sequoia Turner. The natural and necessary consequence of getting shot with an AR style rifle is death. It's murder. It's not even the intention to violate the law, to violate a criminal statute. It means simply the intention to commit the act that is prohibited by the statute. The state must prove that this defendant caused the death of another person, here, 8-year-old Sequoia Turner, unlawfully and with malice aforethought. The judge is going to talk to you about what that very antiquated term malice aforethought means. Malice is not necessarily ill will or hatred. Rather, it's the unlawful intent to kill. You may find malice when the circumstances show that this defendant acted with deliberate intention to unlawfully take the life of another person, to deliberately fire his high velocity rifle into a car that's carrying 3 people that led to the death of Sequoia Turner. The judge is also going to tell you that malice can be shown where there does not appear to be significant provocation, and all the circumstances show what is called an abandoned and malignant heart. What does that mean? It means no regard for human life. And that's exactly what you saw in this instance. When you take your gun and fire your rifle at least 8 times at an unsuspecting car, that's what we call an abandoned and malignant heart. That's when you take someone's car, throw it on the ground, you stomp on it. That's all it is. It's when you have absolutely no regard for human life, when you have absolutely no regard for a little girl who's just trying to get home to play with her cousins. The judge is going to tell you the murder. The state doesn't have to prove premeditation to prove murder. If the killing is done with malice, it is murder regardless of how brief the malicious intent existed with no specific length of time. The judge is going to tell you one instance in a moment that if malice was in the defendant's mind at the time of the act of killing and moved the defendant to do so, that's enough for the killing to be murder here in the state of Georgia. The state does not have to prove motive. I would submit to you, ladies and gentlemen, the moment there was motive. The motive was clear. It was defendant and his members of his illegal barricade militia felt disrespected, and because of that disrespect, they just opened fire on the vehicle. Corey was just riding home. The judge is also going to tell you the elements of felony murder. And felony murder, you can find them in counts 2 and 3. And with felony murder, there's always going to be a predicate act. In this instance, predicate acts are aggravated assault and criminal damage to property in the first degree. And the judges want to tell you, unlike malice murder, felony murder, no proof of malice is required. You don't have to show you express or imply malice we just talked about. There's no intent to cause the death. That's not required. What's required is that the death occurred while the defendant was engaged in the performance of a felony act, an aggravated assault, criminal damage to property in the first degree, shooting into that vehicle, and someone dies as a result of it. That's felony murder. Again, that's the natural and necessary and expected consequences of an act, such as the one that this defendant committed on July 4th of 2020. And again, the predicate acts are aggravated assault and criminal damage to property. The judge is going to tell you about what aggravated assault with a deadly weapon is. Pretty straightforward. It's self-explanatory. For once, it's an assault with a deadly weapon. The judge is going to say that as a matter of law, a firearm, a rifle, a handgun, things of that nature are considered a deadly weapon as a matter of law. To constitute an assault, actual injury need not be shown. The evidence only must show that the defendant attempted to commit a violent injury to the person of another. As it relates to little Corey Turner, her mother Charmaine, and Omar Ivory, we have both. We obviously have a devastating injury caused to Corey that ended her life. But then you have no injury, but obviously the intent to provide a violent injury was there and provided as it relates to both Charmaine and Mr. Ivory. They just got lucky. They survived. You're also going to see 2 counts 13 and 14, with the very same charges, very same elements as it relates to McCord's, Samantha, and Christopher. And as you saw on the video, after that distinct clothing was seen in the Mark video, as Detective Shepard described, black do-rag, twist, red shirt, white lettering on the shirt, AR style, firearm, black satchel, light pants, and a light-skinned individual. 8 identifying characteristics that he looked for painstakingly in every video, every second, and every footage he watched. Now, I'm just going to say about criminal damage to property to first degree, exactly what it sounds like. It is knowingly and without authority, interfering with somebody else's property, and while doing so, you do it in such a manner you endanger human life. You can be straightforward. Think of an AR rifle fired into a Jeep. In this instance, endangering the lives of everybody in that vehicle and ending the life of Sequoia's presence. Shooting that vehicle and all on the driver's side 8 times. Shoot the driver's side back. The judge is also going to talk to you about the possession of a firearm and possession of a felony. Again, not a mystery. The state must prove that the defendant had a firearm on his person or within arm's reach of his person while committing. Just going to tell you at least one of the following acts we talked about here today: murder, felony murder, aggravated assault with a deadly weapon, as it relates to both Ms. Turner and Mr. Ivory, and then the courts, and then criminal damage to property in the first degree. But the defendant was using his rifle as he described in his video that you saw during the testimony of Special Agent Coleman in a berserk way as he took that gun and fired it 8 times at Charmaine's cheek. Here, just some photographs, the defendant with his firearm as he's committing the aggravated assaults against both Mr. and Mrs. Porter. Showing the defendant in the exact same clothing that Detective Shepard described that you just saw in a different angle. And the judge is going to talk to you about the remaining counts 9, 10, 11, and 12, and then 17, 18, 19, and 20, which involve the violation of the Street Gang and Terrorism Prevention Act, the gang counts, and the indictment. The judge is going to talk to you about each one of the subsections, subsection A, B, and subsection E. You're going to hear about the elements of each one of these counts as it relates to what's required for subsection A, what's required for subsection B, and what's required for subsection E. The judge is going to define and give you information as it relates to participation in criminal street gang activity and what that means. The judge is going to tell you that person commits the offense of the violation of the Georgia Street Gang Terrorism and Prevention Act, the gang count, when that person, while associated with a criminal street gang with high bloods, commits a crime that constitutes criminal gang activity. What's criminal gang activity? In this case, the judge is going to tell you it means commission, attempted commission, or conspiracy to commit, which we talked about, any offense that involves violence, aggravated assaults, for example, murder, felony murder, and the possession of a weapon or use of a weapon. Here, like we just talked about, murder, felony murder, aggravated assault with a deadly weapon, criminal damage to property in the first degree, and possession of a firearm during the commission of those certain felonies. The judge is going to tell you, you are to consider criminal gang activity. She's going to talk to you about the tools that you are to utilize when you go back during deliberations and how you are to consider and how criminal gang activity can be shown. The judge is going to tell you that the commission of any offense that would constitute criminal gang activity by any member or associate of an alleged criminal street gang, here at the High Bloods, and that you are able to make that determination as it relates to whether there's the existence of criminal street gang and criminal street gang activity by looking at those offenses, by utilizing the information that was provided by Special Agent Coleman, information that was provided by this defendant in his Instagram, as it relates to his membership and association with High Blood. The judge is going to tell you for the subsection A counts 9 and 17, that the state must show beyond a reasonable doubt the existence of a criminal street gang, here the High Bloods, that the defendant is associated with that criminal street gang, the High Bloods. He told you that in his own words and what Special Agent Coleman described as his autobiography, outlining his gang membership not only in the High Bloods, but in the G-Shine sector of the Bloods prior to that. And then the judge is going to talk to you about that the defendant committed or participated in criminal gang activity, and that the state showed a nexus or connection between the crimes that were committed, the aggravated assault, the murder, the felony murder, and the interest of furthering the interests of that gang. And here, as Detective Coleman talked about during his testimony, was clear that the acts that were committed, the acts that killed Corey Turner, were all due to the disrespect that was shown to this defendant and the members of his gang. That they didn't stop, they didn't bow down, they didn't submit to the authority of this defendant on July 4th, and they paid the consequences for it. It's as simple as that. She's going to tell you for counts 10 and 18, which is subsection B of our gang act, that the state must show the existence again of a criminal street gang, that the defendant is again associated with that criminal street gang, and that the defendant participated again in criminal gang activity. And you did all of that in order to maintain and increase his status or position in the gang. And you heard from Detective Special Agent Coleman about how one increases and maintains status and a position in your gang, about rank. He told you it's not about things of that nature, of doing things in a highly visible manner. And because of that, you gain respect. You put in the work, and people watch you put in the work, the way Special Agent Coleman described it, which is exactly what happened here. This was, as we heard from Ms. Salloway yesterday, this was a crowded area. It had been crowded for since the death of Rayshard Brooks. I think she said she's started going into that vacation at university and prior the very next day on June 13th. And then from June 13th on, it was her core, I think she said 10 to 20 people. And then every day, hundreds of other people showed up to protest and support the movement as it relates to the social injustice, as she described, for George Floyd and Rayshard Brooks. And at some point, this defendant took that movement over. That on July 4th of 2020, this defendant and members of his armed militia took that movement over and turned it into a deadly celebration on the 4th of July. It's as simple as that. When did that in front of all of those people, as you saw in the video, and as was described by Detective Shepard, as was described during Special Agent Coleman's testimony. And then lastly, counts 11, 12, 19, and 20, which are your subsections E of our Criminal Street Gang Act statute. Again, the obvious existence of a criminal street gang, that the defendant encouraged another to participate in criminal gang activity, and that the defendant was at the time an associate of the criminal street gang here, the Pirate Bloods. They're just going to tell you that as it relates to the term participate, that it means to take part in something, to share in something. Clearly, they were all taking part and sharing in the blocking of this road, the prevention of citizens being able to travel freely about the area prior to the university. It's not complicated as it relates to the elements of this crime because of the obvious nature and the in-your-face ways that this defendant, members of his wannabe militia, acted on July 4th of 2020, acted unknowingly that was being reported by the local businesses and areas around, thinking that their dominance wasn't going to be collected by video evidence, that they would be able to continue to dominate that area without any consequence, without Detective Shepard being able to go through the hours of footage to find his distinctive look. The judge is going to talk to you also about what a criminal street gang is here, as you learned through Special Agent Coleman. The existence of a criminal street gang may be established by evidence of the name, Pirate Blood, the Bloods, and the signs and symbols, tattoos, the graffiti, things of that nature, attire that gang utilizes in advertising with to get their customs and behaviors out to the members of the public. You're out to people prior to the university, the fear that they wanted to spread. Some examples that the Special Agent Coleman described as it relates specifically to the Pirate Bloods. Ad nauseam, we talked about the red color, the red attire, red tattoos, things of that nature, the 5-point star, and the red accents in the tattoos. The Elm Street reference, the 700 block reference, the 365, the anniversary for the members of that gang, red bandanas. And he described the distinctive characteristics of not Bloods, but the Pirate Bloods, that their distinguishing and distinctive characteristic is their vibrant ways in which they spread their dominance, in which they assert their authority, which is exactly what you saw on July 4th of 2020. Nothing different, nothing unexpected. And I was thinking about an example as it relates to the defendant's tattoos. You heard on Cross, especially from Coleman, about the ice skate tattoo that was across the defendant's hand. And you heard a number of companies in the defense counsel Hoover about this ice skate, what it means, and its company, and things of that nature. And all of that may be very true. And you heard Mr. Hoover talk about some characteristics, and I think he said he had a 5-point star tattooed somewhere on his body. And then he talked about his family from Chicago. I couldn't remember the last thing that he said as it relates to trying to compare the defendant's ice skate to the use of ice skate on his hand, and then the use of it along with other gang characteristics in his Instagram. But I was thinking, Mr. Hoover's exactly right. So the fact that he has a 5-point star, that he's from Chicago, I think he said his dad's name is, I can't remember, his last name is Hoover. That doesn't make him a gang member because he's got a 5-point star and he's from Chicago. The last characteristic he said, because he doesn't incorporate that, or he doesn't use that in conjunction with gang activity. He doesn't use that to advertise gang membership. Like this defendant, he would write I skate with mob, he'd write I skate and then put, Elm Street block 700. I mean, that's the point. I have a 5 on my wrist. It means nothing but 5. But if I was to put that 5 on my wrist of a photograph next to Elm Street Bloods, well, you're sending a message. That's the point that Special Agent Coleman was making. Not that everyone who has a 5-point star, everyone who has a red, whatever, 5 on their arm, or a tattoo that could be considered, a gang identifier, is a gang identifier. It's what it's used in conjunction with. It's the behaviors, it's the language, it's the message that you send along with your tattoo, which is exactly what this defendant did throughout his Instagram. He talked to you about some of the graffiti that he saw in relation to the area of Wendy's where Mr. Brooks was killed. He talked about the identifier as it relates to Mr. Brooks being a member of the Pirate Bloods, and that being the purpose and why the members of the Pirate Bloods gathered in this area, the things that he saw. Then he talked to you about what we just referenced, some of the common signs and symbols of members of the Pirate Bloods, all found on the defendant's Instagram states exhibit 153. Special Agent Coleman talked to you about those hand signs, what they mean, the message, the significance that they are to the members of the Pirate Bloods and his defendant, Julian Conley. He talked to you about each one of these hand signs and why it was important to his analysis. That this defendant was a gang member, this defendant used his gang membership to commit criminal acts. Why the tattoos on his body were significant as it relates to his ultimate opinion and conclusions. Talk about the background of not only Bloods, but specifically the Pirate Blood sect, how and why it's a criminal street gang. We talked to you about this defendant as he referenced his autobiography, and as you can see, admitting he was fired in blood, or he was fired in blood when the G-shot said that blood. So not that somebody said to him, oh, it is autobiography because he's the author, ladies and gentlemen. He is sending that and letting whoever he's sending it to know his affiliation and his background. The judge, as we talked about, is going to talk to you about the use of firearms and possession of firearms and how that relates to criminal or gang activity. We saw firearms all throughout this defendant's Instagram, having a meeting and his want for the back.
Drug nigga in the fold. Everybody sitting in the around here. Play nigga, keep a gun. I keep a Glock G-lock in my back pocket. Pocket rocket, let it pop it, let it go berserk. Blood stains on my shooting on my t-shirt. Said the nigga moving pounds, but it's sheep work. Yeah.
I played it a few times, but especially at home. I want to play it again for you, ladies and gentlemen, today, because that video describes exactly what this defendant did on July 4th, 2020. He used his gun, and as he described, he let it go berserk. So it stains of blood on his shirt. On July 4th of 2020, the stains, the blood on his shirt was of an 8-year-old child. An 8-year-old child. 8-year-old Security Turns. Again, more photographs, firearms. After the incident, this defendant is seen again a few hours later. Same shirt, same satchel, same firearm. And ultimately, Detective Coleman, or Special Agent Coleman, talked to you about the circumstances surrounding why this defendant was there, why members of his gang were there, why that territory was important to the Highway Bloods, and they engaged in this pattern of criminal conduct as they were blocking the roadways, that if you didn't submit, that you were threats of violence and actual violence was imposed upon you for not submitting to their authority. And then lastly, as it relates to subsection B, the judge is going to talk to you about, again, the existence of a criminal street gang being required. The defendant encouraged to participate in criminal gang activity. That the defendant was at the time an associate or member of the criminal street gang here at the Highway Bloods. What do we know about July 4th of 2021? We know that this defendant was exerting authority with members of his gang. He was doing so so he could control the area of fire at the university, that people would submit the power and the authority that he exhibited and exuded, and if he didn't, his eyes, disrespect. Anyone who disrespected him, we have met with violence, threats, in this instance, death. Little Sequoia Turner died because her vehicle just attempted to go home. Little Sequoia Turner died just because she wanted to go play with her cousin. And that wasn't convenient for this defendant. Now, in a moment, I'm going to sit down and that's an opportunity to address each and every one of you. And then Ms. Young will have an opportunity to go through all of the facts and the circumstances from July 4th of 2020. Everything that you heard as relates to the testimony and the evidence during this trial.
You guys ready for the defense argument? You need a break? You do need a break? You ready? Okay. Okay, counsel, you just let me know a few minutes ago that your screen is not working. Do you need that? It's back up? Okay. But you can feel free to turn that however you want to, and we can also call for tech help if you need it. Do you want to get started?
Yes.
Okay, go ahead.
Yes, it does.
That's fine, yeah.
We've gone from gang to armed militia. And I guess if we go much longer, we'll be a terrorist organization. But as I said 1 week ago, when you rush to justice by rushing to Julian, you disregard the fact that the math, the mom, and the man behind the wheel all agree. Julian did not do it. When you rush to justice by rushing to Julian, and Detective Shepard is your shepherd, you end up lost in lies, half-truths, conflation, and exaggeration. Detective Shepard could not utter a sentence without a noun, a verb, and Julian Conley did. A noun, a verb, red distinctive shirt did. A noun, a verb, red distinctive shirt, white distinctive writing, dangling AR-15 in a satchel. Detective Julian Shepard, J-A-R-I-O-N-S-H-E-P-H-A-R-D, sat there, blue suit, gray shirt, blue and yellow tie, dangling lies, half-truths, conflation, and exaggeration dangling from his tongue. Again, my name is Arnold Regas, and I am proud that I am joined by Mr. Sean Hoover and Ms. Aisha Broderick. And it is the pride of our lives and careers to stand next to this young man, Julian Conley, and his family, while they stand next to Shepard, a man who wouldn't know the truth if it smacked him in the face, unless it took less than 8 days to find it, because the investigation took 9 days, except when he sat in that seat, he may have said, well, I may have done that in 8 days. Julian deserves better than 8 days. You deserve better than 8 days. Sequoia and her family deserve better than 8 days. You talk about that beautiful young girl wanting to go to Spelman, loving to dance, loving to love, loving life. And you take 8 days to investigate. He sat there, blue suit, gray shirt, blue and yellow tie, dangling lies, dishonesty, deception, half-truths, conflation, and exaggeration. And I apologize, I'm emotional, I'm loud, I can't help that. I know the state said it's not about emotion, it's not about passion, but I'm gonna be me, I can't.
Okay, y'all, hold on a second. I feel like Regis's presentation really needs to be seen on this screen so y'all can get the fullness. Okay, hold on a second. Let's just do a sound check, make sure we're good, because he's getting ready to change. He's gonna put on a bunch of red. He's getting ready to put on a show for y'all, and I don't want you to miss it, okay? So okay, hold on.
You talk about that beautiful young girl.
Y'all can hear okay, right? He getting ready to put on a whole show for y'all. So he needs to stop playing.
I have to give Detective credit.
Okay. Y'all, we can hear, right? Sound check good. All right, let's get back into it. Hold on, let me get it to the beginning so y'all can see the show. Girl, he brought props. Instead of doing a PowerPoint, girl, he bought costume change. Okay. Y'all. He said, let me go see if I can find some red jackets and stuff. I know Hoover is like, the bougie gang is roasting me right now. And we are. And we are. Okay. All right, let's go.
Wanting to go to Spelman.
Did we am I at the right spot? Hold on.
Lies.
Am I at the right spot?
Half-truths, conflation, and exaggeration dangling from his tongue. Again, my name is Arnold Regas, and I am proud that I
I'm sorry, I didn't know his name was Arnold. Okay, Arnold.
am joined by Mr. Sean Hoover and Ms. Aisha Broderick. And it is the pride of our lives and careers to stand next to this young man, Julian Conley, and his family, while they stand next to Shepard, a man who wouldn't know the truth if it smacked him in the face, unless it took less than 8 days to find it, because the investigation took 9 days, except when he sat in that seat, he may have said, oh, I may have done that in 8 days.
Wait a second. I'm sorry. So it's professional to drag the detective? Is that what we're doing now in 2025 in closing arguments? You're going to drag a detective because you don't like that they came up with your person? That's really unprofessional. That's really, really that is common. Okay, my bad. I haven't been to criminal court too much, but okay, I didn't know that's what they do. That's awful. You don't like their conclusion, so you drag them? Not just, hey, they got it wrong. I wish they would have spent a little more time type of thing. They're just going to drag him as a professional. Wow. Okay, Arnold. All right, I'm going to stop interrupting. Okay.
Julian deserves better than 8 days. You deserve better than 8 days. Victoria and her family deserve better than 8 days. You talk about that beautiful young girl wanting to go to Spelman, loving to dance, loving to love, loving life. And you take 8 days to investigate. He sat there, blue suit, gray shirt, blue and yellow tie, dangling lies, dishonesty, deception, half-truths, conflation, and exaggeration. And I apologize, I'm emotional, I'm loud, I can't help that. I know the state said it's not about emotion, it's not about passion. But I can't help that. I am a poor kid from the projects of New Orleans, the Callio Project, and this is just who I am. But when you rush to justice by rushing to Julian and Shepard is your shepherd, you're left with lies, half-truths, exaggeration, and conflation. And he knows it. He knows it. Ladies and gentlemen of the jury, I like red too. My fraternity loves red. Sometimes I walk around with my red backpack and I'll hear judges talk about you in that red backpack. I see you walking all down the street with that red backpack. It's the first thing I notice. Before I notice your 6'4" person behind in chambers, I notice that red backpack. Because it kind of stands out. Well, ladies and gentlemen of the jury, and I don't do this to be hokey or corny or inflammatory, but this case is brought to you today, or my closing is brought to you today, by the color red. years ago, two years ago, my wife and I went to a football game. We went to see the University of Georgia play. Had really good seats. But the problem is, they were on the visitor side. And I bought this red jacket to stand out to show my support for Georgia. And I thought it would make me distinctive when I watched the game in the opposing side. But it didn't. Because it was a Peach Bowl a couple of years ago, and they were playing Ohio State, and they wore red too. I didn't stand out at all. I bought this bright.
Is his zipper broken? Look at his zipper.
I didn't stand out at all.
Ah, his little Amazon jacket.
Because it was a Peach Bowl a couple of years ago, and they were playing Ohio State, and they wore red
All right,
too.
let me
I didn't
stop.
stand out at all. I bought this bright red jacket for nothing. Because I sat there and there was nothing distinctive. It was just me in a sea of red. But the case talks a great deal about the distinctive red shirt, and I will try to get it right from the lips of Shepherd. Red shirt, distinctive white lettering, light colored jeans, satchel, dangling AR as he sat there in a blue suit and gray shirt and yellow tie, dangling lies, half-truths, conflation, and exaggeration. I don't know where to begin with him. But I'll do it in less than 8 days. Because I don't want to take too much of his time, because on the 9th day, I guess he has something else to do. 8 days. Sequoia deserves so much more. As I said, I'm a poor kid from the Calliope. And I don't have a brother or a sister. I'm an only child. But I have daughters. I'm a girl dad. I have 2 daughters. I am a girl granddad. I have a girl granddaughter, Ava. Sequoia should have gone to Spelman. My daughter, my younger daughter, went to an HBCU. She didn't go to Spelman, she went to Howard. HU, you know. And to say that it took me 9 or 8 days, because within that 8 days, he had clues upon which he never acted upon. Within that 9 days, he was told things that he did not bother to pursue. But first, we're going to talk about a few of his lies as he sat there with that smug face. He talked about the fact that Omar Ivory showed him some pictures of the people he saw shoot. But when that man, Detective 1, with a blue suit and gray shirt and blue yellow tie, with lies, dishonesty, conflation, and correlation dangling from his lips, when he sat in his seat, after he raised raised his right hand and swore to tell the truth, the whole truth, and nothing but the truth. He sat in his very seat and said to you, yeah, Omar came to me. There was some information he got offline, and all he did was pass it along to me, but he couldn't confirm any of it. It is hard to tell two lies in one sentence. He managed. Lie one. Omar was merely passing along information. No, what Omar was doing was saying, here are the two people who shot. They're circled. One is tall and dark with a beard. The other is short and light-skinned with dreads or twists. That is what he said. And then that man who sat there with the blue suit and gray shirt and blue and yellow ties with lines dangling from his lips, then went on to say, but he couldn't confirm any of it. Lie number two, because when Omar sat there, Omar said, I definitely told him, those are the two people I saw. When Detective Shepard said, did you see him with your own eyes? Omar said, hell yeah, I saw him. I won't lie about nothing like that, dog. Hell yeah, I saw him. Those two people I have circled. Those are the two people who shot Sikori. Dressed in black, dressed like bounty hunters. That is what Omar said, but what he said was, just passed along the note. Couldn't confirm anything. One sentence, two lies. I bought this to go to a fraternity function like 30 years ago. Once again, it wasn't distinctive because everybody was dressed like me. And then Detective Shepard said about the McCords, he identified that person went to his car. He said that person had on red when he went to his car with the shotgun. That was not true. The McCords, Mr. McCord, said that a person came to his window with a shotgun wearing black. And another person was standing in front of the car wearing black. Now, I want to be clear. I know nothing about guns. Despite what I do, I know nothing about guns. But people keep telling me there's a big difference between shotguns and rifles. Fine. But no one ever said anything about Julian with the shotgun. It was always red shirt, white distinctive writing, light jeans, satchel, dangling, not a rifle. But he sat there and said the McCords identified him and his red, untrue. But when you rush to justice by rushing to Julian, sometimes the truth doesn't matter. And when Shepherd is your shepherd, it certainly will not. So let's talk about what they said. They said they saw the barricade. They He went around the barricade. I think Omar said he may have slowed down for a second, but then he accelerated around the barricade. And that's when they saw people there. The people were saying, whoa, 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 as if to try to get them to stop. But then Omar proceeded through that barricade, sped up, went a little faster, and went through that barricade. And when he went through that barricade, people started shooting. They got down to that second barricade, and eventually they got to a place and they stopped. And they turned around. And about 3 or 4 minutes later, they came back through the area. They came back through that area where those bullets had met them once before. And then he said he drove to the hospital with 2 flat tires along that ride, whether they were shot out or what, we will never know. But 2 flat tires. He got to the hospital. And that's when he got out again. He started talking about, I'm gonna get me a lawyer. He said what he told you. I'm gonna get me an attorney. The attorney went inside. And then you heard from the officer, first one on the scene, the first one, that the first description he got was people in black. People in black, or a person in black. And then a day or so later, Detective Shepard, went and talked to the families. He said he wanted to give them time, so he went and talked to them. And what he said when he testified was that, so Ms. Turner mentioned a couple of different people. She mentioned a person in black, but she mentioned a light-skinned person with twists. I think I won't call that a lie, but as the saying goes, there are lies, there are damn lies, and there are half-truths. Well, that was a half-truth. That was a half-truth, because what Ms. Turner said was that there was a light-skinned person with twists, wearing all black. Keep in mind that that is the identical thing that Omar told him of the person that was circled. Light-skinned person, short with dreads. Nothing different. But when he testified, he failed to mention the part about her saying that that person, the light-skinned person with dreads, that Omar described and showed to him was wearing all black. Because you rush to justice by rushing to Julian, and shepherd is your shepherd, truth don't really matter. She said all black. And then another point, she said black pants and a white t-shirt. Never did she ever say the word red. And speaking of red, I feel a little ridiculous now.
As he should. As he should. When you rush to judgment, you rush to Julian, and shepherd is your shepherd. I'm like, y'all, this is so bad. It's bad.
She never mentioned the word red. Then, of course, as we talked about, when Detective Shepard, their shepherd, met with Omar later that day with that picture, he never mentioned the word red. I like red. I think red stands out. Red is the kind of color you notice. You notice red. There's a person sitting on the second row now. I don't even have to look, but I know that she has on red. I know that when the McCords got out of that car, Mrs. McCord had on red. They talked a great deal in their opening about distinctive red. How distinctive is it, yet no one noticed it? And that's because the math, the mom, and the man behind the wheel all agree. Julian didn't do it. Because had he done something, they would have said the dude in the red shot, that guy in the red shot. The guy in the red put a gun to my face. But what you have here are quite a few failures. As the state just talked about, gang, inflammatory word, gang, and more inflammatory words, armed militia. There's an elephant in the room, and I don't mean Delta. There's an elephant in the room. The city of Atlanta abandoned them. The city of Atlanta said, y'all good over there. So when you talk about this armed militia, when you talk about this gang, when you talk about this, I call them a terrorist organization, beat it to the punch. Talk about the failure of your government. Abandon them. You heard that detective say that, yeah, they call that an autonomous zone. It didn't make sense to me. We didn't even go over there. We left them alone. Shepard even, I'm sorry, let me give him his proper respect. Blue suit, gray shirt, blue and yellow tie with lies and dishonesty and half-truths dangling from his tongue. Even he said it was an autonomous zone. They abandoned them and came up with a really catchy word, a catchy phrase for it. No, that's abandonment. You don't get to rebrand your dereliction of duty and blame someone else for it. They weren't there with guns by choice. They were there because in their minds they had no choice because the city of Atlanta abandoned them. The city failed them. And you talk about it being a gang and a militia. Did you hear Miss Alloway yesterday? Did you hear the anguish in her voice? Did you hear her tell you that we were there because of injustice? We had George Floyd, Ahmaud Arbery, Rayshard Brooks, and that's why they were there. She went to that Wendy's the day after it burned down, after Rayshard Brooks. I'm going to ask a rhetorical question. Why do people say Black Lives Matter? Why did Black Lives Matter become a rallying point? A dumb example. My wife and I were in China once, and one of us said, why do I see no Chinese food restaurants here? Well, because it's just called food in China. Because it's there, you know it's there. Why do people say Black Lives Matter? Why does it become a rallying cry? Because they feel Black lives don't. They have to say it over and over again, convince themselves, and maybe they'll convince others. We matter. That's why she said they were there. It had nothing to do with gang activity. It had nothing to do with being an armed militia. It had everything to do with saying we matter. See us, feel us, understand us, if you will. And that's why they were there. She told you that every day. It was a group of 10 or 20 of us every day, but then every other day, hundreds or so people may come by and take pictures and tag themselves. It had zero to do with gangs and everything to do with community. Did you hear the video they played of the bus? And man went to that bus and said, wait a minute, they're for the community. Let them through, they're for the community. Because that's what it was about. It was about community. It was about, damn it, our lives matter. See us, feel us. And perhaps, if you will, try to understand us. That's why they were there. And to call that an armed militia. To diminish that to gang taking over that barricade. No, Miss Alloway told you she was there too with her AR because our government abandoned them. Our government failed them. Our government said, nah, dog, y'all good over there. In fact, even after the shooting of that beautiful little girl, even after, they didn't come. They went to a staging area a half mile away. The man with the lies dangling from his tongue told you that it was about 12:30 or 1 o'clock before he got there. Well, it happened at 9:45. But the city abandoned them. 9:45, and they got there 1 o'clock or so. They went to a staging area. But even worse, at some time prior to 9:40 is when the McCords say they went there. And we know the McCords went there. We know the McCords called the police. They called the police. And the police, they were a half mile away. Query me this. Had y'all gone there when she called? Had they gone there when the McCords called? Had your police responded when the McCords called? No, it's a failure on so many levels. You know, we watched that video, and I believe we played all of it. It's 10 minutes from 9:40 to 9:50 on University Avenue from camera 2, and we're going to show it again. When I asked that first officer, when I said the mood was festive, wasn't it? Or they may have asked it, and he's like, with disdain. I didn't find anything festive about it. There were kids doing cartwheel. I ain't seen anybody doing cartwheels. There are people cooking out. Well, you can call it that if you want. The disdain in his voice for the people left abandoned. I have to give Detective Shepard credit for one thing. For a bit of humor. When Ms. Broderick asked, weren't there kids there? His response was, I ain't seen the kids. I call that a small adult. Huh? Well, when you watch the video, you'll see that small adult doing cartwheels and backflips. The small adults love cartwheels and backflips, clearly. But he couldn't even admit that. He couldn't even admit that. But they talk about this was gang activity. I don't have a lot to offer you. I don't have a lot to offer you. The one thing that means everything to me when I stand before you humbly, to the extent I can be humble. But when I stand before you humbly, the one thing I offer you, the one thing, and that's credibility. Because that's the kind of thing that when you lose it, I don't think you get it back. And I don't know that you deserve to get it back. And I want to maintain my credibility. I don't want to say anything to you that's not true. And I hope I don't by mistake somehow. But credibility is everything to me. And when that man looked at that video and saw cartwheels and said, I didn't see adults. I didn't see children. I saw small adults. Come on. Come on. As he sat there with that smug look on his face. But now is the time I would love to be able to walk over here and look at Julian and look at his family. I would love to be able to say, Julian was not in the gang. He was just a gapper. He was just a pretty noob. That's all he was. He was just a gapper. But I can't. Not credibly. I am not going to do there were no children, there were small adults thing for you. You deserve better. He deserves better. Deserve better. Julian was in the game. Julian was a dumb 19-year-old kid from the suburbs with law enforcement parents and decided that he wanted to be a pirate. Julian was a dumb 19-year-old who decided he wanted to be a rapper dog. I don't know if kids say dog anymore. He wants to put on the grill and grab the mic and rap about niggas and bitches and all that stuff because he's a dumb 19-year-old. A dumb 19-year-old say they say was the leader of the pack. They say when he went to that bus with that older dark-skinned black guy who was saying, y'all in the community, y'all going through. They say, oh, that's Julian's leading that. Julian is leading that. See, that's just... I am not going to lose my credibility for the sake of any case. But when you rush to justice by rushing to Julian and you can't bother waiting for 10 days, 10 days is too many. The things like truth and credibility are out the window. But they call that a gang. Because when this happened, July 4th of 2020, 5 years ago, and whoever wrote up these charges, and they went our district attorney's office. A year or so later, they said, it looks good. It looks good. It looks really good. But you need to add something. Can you take this and see if you can find a gang angle to it? And then it was turned over to Homeland Security and whoever to look for a gang angle. To look for a gang angle, to search for a gang angle. Let's check his Instagram. Let's see what Instagram says. And Instagram said a lot. Instagram said he was a dumb 19-year-old looking to be cool, joining the gang and trying to be a rapper. Dog. But as the saying goes, when your only tool is a hammer, every problem is I know y'all said it to yourselves, nail. When the only tool is a hammer, every problem becomes a nail. They decided that the police should look for a gang angle a year or so later. And Coleman, Special Agent, Homeland Security, whatever, his title is not as nice as Detective Shepard's. He said that I looked at that video and I saw he had a leadership position again because that dumb 19-year-old went to a bus with an older guy, as the older guy said, no, come on through, you're from the community. But that somehow became him. Let's watch that video. We're gonna try it again, maybe. I don't know if you could hear the part about, you hear from the community. Let's play it again. Let's play it again for the cheap seats in the back.
There's any microphones on over there that's causing the echo.
So, in that video, you have the 19-year-old and the older guy walking to the bus. The 19-year-old was somewhat a few paces behind the older guy, and the older guy is saying, "You're for the community. Let's let it through." And you have the younger 19-year-old guy standing back there. Didn't exercise any veto power or say, "Hell yeah, let's let him through." That's what I said first. No. Just a young 19-year-old following the crowd in that case, except in this case, he was following it for what he believed to be a noble purpose. Let's talk a little bit about the testimony. words like Black Lives Matter. Or at least they should. I don't know if you remember, again, way back when I stood before you and I did what's called an opening statement. And I never know quite what the evidence will show. I try to guess what the evidence will show, and I cross my fingers and I hope to get it right. But when I stood before you a year ago when I did it, I was terrified. My voice was cracking. I think I misspoke a few times. And what I said was something about when you rush to justice by rushing to Julian, it invariably, something I said. And I said that, but when the mom, and the man behind the wheel all agree, or at least they did. I said that because I didn't know what they would say when they testified. And I didn't want to say that they agreed that he didn't do it, but I knew I would say they agreed because of what they said then. But when they testified, I was expecting them, one of them, any of them, all of them. They could have stood up and said it in unison. I was expecting for them to say, do you see the man, one of the men who fired those shots that night in his courtroom today? Do you see him? And I was expecting them to stand up because I didn't know, yeah, that's him. But they didn't ask that question. They did not ask that question. And there can only be two reasons why they didn't ask it. Either because they didn't know what the answer would be, or because they knew exactly what the answer would be. And then, when Omar sat there, I was waiting for them to ask him. Omar's a wild card. Do you see that person or those persons in that picture you photographed, or the people who shot at you? Do you see that person in this courtroom? I was expecting him to say, yeah, dog, I see him. I see him right there. But no, they didn't ask. And they didn't ask, and there can only be two reasons. Either one, they didn't know what he would say, or number two, they knew exactly what he would say. But they didn't ask. They did not ask. Yet, when young lady Jasmine from Cobb County, who loved sitting there, I think she gave you all a peace sign when she walked out, loved sitting there. When she testified about the gender reveal color thing that somebody threw under the car, they had no hesitation. They asked her, do you see that person in this court right now? She stood up and said, yeah, that's it right there. And when Shepard sat there,
My bad. Eve, you have a good point. I wanted to say, like, he's testifying. Is he giving a closing? Like, they really could be objecting right now. And I know sometimes some of the, they don't like to, have objections during like closing or opening statements. But I think he's not closing. He's not giving any additional information. They stated at the beginning that they were going to prove that Julian did not do it. They're not proving anything. He's just going through his beef with why they came to Julian, how they came to it, what the circumstances were at the time, his beef with the detective, and that's pretty much it. It's like he's not really giving a good argument as to why it wasn't Julian, any proof it wasn't Julian, any reason why the person who's already admitted guilt may be the person, who knows, but nothing. Yeah.
He knew what he was gonna say. They asked him, do you see the person? Oh yeah, that's him right there. Red shirt, distinctive lettering, light colored jeans, satchel, AR dangling. He is the only person I've ever seen to look at a black and white video and say that's him in a bright red shirt. They never asked that question. I hope what I say doesn't come across as being cynical. I have a great deal of respect for Ms. Turner. As much as they wanted her to say she saw somebody in a red shirt, she never would say it. All she would say is black shirt, or at one point, white shirt, black jeans. She never would say red shirt. Never. Omar. And I can't help but sometimes come across as being a little bit mocking. A little bit. I can't help but have a bit of respect for him either, because he never once, as much as they wanted him to, he never once said red shirt. Never once said red shirt. Even when you look at the McCords, he never once said red shirt. They didn't even ask him, do you see the person or people? Never didn't ask him. They didn't even ask his wife, do you see the person? No, never asked. So you have to listen to what they ask and sometimes listen more closely to what they don't, because they only have two reasons for not asking. Either they don't know or they do. But they didn't. So as the McCords drove off that night, made that turn into that package store, saw him pull out the car, pull over the car, and get out of the car with the gun in his right hand. Again, I don't know guns, but he said it's a 380, and my gun people say a 380 is a small gun. But you see him get out that car with that 380 in his right hand. And he said just as much from that stand. He had a gun in his hand when he got out. And I don't know if you listen to my questions or not. I forgive you if you don't. But my question to him was, in response to you pulling out that gun and getting out of that car with that gun, did you even know that those 3 or 4 or however many people pulled a gun on you in response thereto you having your gun? His response was, I didn't even know. I didn't even know. But when you look at that video, you'll see that he pulls that car over, he gets out with his gun, he says whatever he says, he turns around, then his wife, in her distinct red, gets out of the car, and she says something, and then they get back in the car, and then they drive off. And then after, you see dumb 19-year-old come over with his gun. He didn't even shoot at the people who had a gun in his hand, yelling at him. You see him come out, get out of this, walk over there, and does a little thing like this for a second, and turns around and walks away. And the courts never do anything about that. Hey, we're gone. You know, I really enjoyed learning a little bit more about Mr. Body. I have to say that. You know, I don't know if you all gather this throughout this process, but I'm going to speak for myself. We don't hate each other. In fact, I think they're good people, great lawyers, better than I can ever be, but great people. I really respect, well, most of them. I haven't gotten one of them, but just a good guy. But a trial is not about us. It's not about me. It's not about them. And to some extent, of course, it is about him. But it's also about us, the collective, all of us. A trial is about who we are and who we say we are. It's about what the judge is going to tell you. They have the burden of proof. He has nothing to prove. Zero to prove. He doesn't have to say anything, do anything, show anything. All he has to do is sit there. Nothing to prove, and they have everything to prove. That is about who we are. So it's not about, well, he didn't do this, he didn't do that, I wish he'd have done this, but then he ain't got it, because that's who we are, and that's what we say we value. So it's about him, yes, not about him, not about me, about us, about what we say, the values that we say we hold dear. It's about, the judge is going to tell you that if you have a grave suspicion that he did it, and only a grave suspicion that he did it, your duty is to find him not guilty, because a grave suspicion isn't sufficient. The judge is going to tell you that you can only convict if there is no reasonable alternative theory consistent with innocence. The judge is going to talk to you about reasonable doubt. And as Mr. Abadi said, you know, lawyers, we screw things up. I don't know if he said that, but I think he meant that. We screw things up with words. We take words that should be simple and we butcher them. We mess them up somehow. A couple weeks ago, I was in a trial in Clifton, Georgia. And the judge did something I've never seen a judge do. At the start of the trial, Judge Reinhardt, he said, call him Bill. He read the Pledge of Allegiance. And I'm thinking, what? In the courtroom? You know, a little separation of this? Details. And I'm going to be, again, as Mr. Body was frank with you, if I'm going to be a little bit frank with me, rightly or wrongly, I've never considered myself a patriot. I thought you sort of had to somehow earn it. I'm not like Ms. Broderick, a veteran of war. I didn't think I earned the right. But it took me to the last time I even heard the Pledge of Allegiance, and it was at my dad's funeral, when he was given the flag from his military service of having gotten on a boat and a plane and gone to Vietnam. And the minister, who was an officer of the military, talked about justice and what it means and what he fought for. I was like, wow, I believe in justice. I believe in fighting for it. I'm a patriot. And I am. He talked about you don't have to love everybody or like everybody, but that doesn't matter. You don't have to like what everybody says, but that doesn't matter. We're all, as Mr. Body said, we're cloaked. We're cloaked in this thing that has to be more than a thing, an idea that has to be more than a...
Look, I it's a wrap. His closing argument sucks. And it's unfortunate that Julian had I mean, I'm going to be eager to hear what the verdict is because we don't know what the jury is doing. They might be grooving off of this closing. They might not care about the prosecution. They, you know what I'm saying? They may feel like it's the parents' fault for having Sequoia out on 4th of July night. I don't know. I hope it's some reasonable common sense people who can look at the evidence and make a decision. But this clownery is, I don't think, is a way to win a case. It's just unfortunate that somebody has to, their life is depending on this fool. Arnold is awful. Arnold is bad. You know what I'm saying? I mean, it's better when you know someone's got a fair fight and someone can deliver the information and at least give people something to think about. It's about like watching Donna Adelson a couple of weeks ago and those clowns she had. That lady was a clown she had as a lawyer. It, you know, it was just a mess. It was so much evidence. But anyway, this guy, I don't, it's like, sir, you keep losing me. Like I get real distracted.
Idea.
Like I can't follow his argument. At least a body with his PowerPoint, you know what I mean? Like you can always look at the screen and like, okay, that's what we're talking about, this or that. This man is speaking figuratively. He's speaking about his father's funeral, where he's from, his daughter going to Howard. I know more about him than I know anything about Conley. Where's his family? What's his parents do? What were his goals? What were his aspirations? Why was he on the streets? You know, what was he doing that night? Nothing about any of that. What did he think he was doing the night that Sequoia died? What's his version of the story of what him and his boys were out doing, whether he testified or not? Like, just nothing. He's not giving anything. He's just talking. And I think he thinks he's really doing something. And Hoover's probably sitting there trying to respond on his 11 other cases he got assigned to him.
It has to be who we are. And this idea, it's not about your suspicion. It's not about, I believe he did it. I believe he didn't do it. It's about, did they prove it beyond reasonable doubt? And that's who we are. At least that's who we say we are. And as, you know, lawyers mess things up, the way I think of reasonable doubt, my wife and I were watching TV a few nights ago. I let her have the remote control this time, or as I like to call it, every time. And she does what she always does. She found her way to a documentary. And this documentary was on CNN. And it was something called, How Did It Happen? Why Did It Happen? Something like that. And it told the story of this young girl. I think her name was Mary Kellerman, a 7-year-old girl in a suburb of Illinois, suburb of Chicago, rather. 6 o'clock one morning, wasn't feeling well, it was time for school. And her dad did what a dad would do. I've been there. My wife's a flight attendant. I was always at home with my 2 daughters, trying to comb hair. Haven't gotten it right with myself. But the dad gave his daughter a pill. And shortly thereafter, he heard her collapse on the floor, dead. And a few miles down the road in that suburb of Chicago, you had the Janus family. 3 people were sick in the Janus family. 3 people took a pill. They all died. 4 people dead near this little suburb of Chicago when someone figured out the Tylenol was killing them. I know Tylenol is in the news now, but we're not talking about that. Tylenol killed them. All in all, 7 people near Chicago died because someone, before the age of childproof locks and all this other stuff, someone had poisoned the Tylenol. 7 people died. And what did Tylenol do? Tylenol removed every bottle of Tylenol off every store shelf in Chicago, in Illinois, in Atlanta, in Idaho, in California. Every Tylenol in the country was pulled off the shelf. Not because the makers of Tylenol believed their product was deadly. They did not believe it was deadly, but they had a reasonable doubt. And that's what reasonable doubt is. It's not about math. It's not a 1 out of 2 chance, a 1 out of 10 chance, a 1 out of a million chance. The numbers don't matter. That ain't about math. It is about reasoning. And Tylenol deemed the threat too severe. The threat too severe. The threat too reasonable. And they pulled it off every shelf. That is reasonable doubt. Or another way to judge reasonable doubt. When the man with the blue suit and the gray shirt and the blue yellow tie with lies and half-truths and conflation and exaggeration says anything, that too is reasonable doubt. Let's watch videos.
I don't know if I would have used that Tylenol analogy. I'm still trying to understand it because if the reasonable doubt, Tylenol had a reason to pull its product off the shelf. Is Julian, in theory, the product that needs to be pulled off the shelf because he's deadly? You know what I'm saying? Like, I don't know that that was a great analogy. Is Julian Tylenol, as in the poison pill, or is Julian supposed to be Tylenol, the company who provided the poison pill? Either way, either the company poisoned the community, the pill poisoned the community by the person who tainted the bottle, but either way, Tylenol was pulled off the shelf. Whether it's the company pulling it or the company pulling the product, who is Julian in that analogy? Like, I don't get it. That's not a reasonable doubt. That is a known threat. I don't get it. Maybe I'm wrong. You guys tell me why it's going, like, it's kind of going over my head a little bit. Maybe I'm thinking about it, but I'm just like, which one's a Tylenol? And it was a poisoned pill. So, and I mean, those of us who are of a certain age, we remember that happened and you couldn't get Tylenol anywhere. But yeah, that was weird. He's not, yeah, it's, I don't feel bad for Julian because Julian is being accused of doing a very bad thing and he has to stand up like a man and be a man and deal with the repercussions of what he's got in store for him. But his lawyers suck, man. They just do. That's just my opinion. And it's just unfortunate he doesn't have at least a fighting chance to have a good defense because these guys are on some clownery. Yeah, I mean,
As best
I
you
think
can.
what happened happened, and Julian, look, I get, he has a right to his defense, but at the end of the day, there's so much video. Sequoia and her family and her and the McCords and the people of that neighborhood who had to deal with the repercussions of this horrible event happening, they deserve to get their justice, period. So, it's if he's not the shooter, at the end of the day, you were in the vicinity when this felony happened. You were in a position, you saw what was happening. You didn't call 911. You didn't do anything to help. You were there in support, and you're going to stand with your people. That's it. That's all.
Of what the night was like. Is anything happening anywhere?
Okay.
You see that small adult doing cartwheels? Small adults love that. Max live too.
It's like, to me, Julian is, so if you guys can see, 1, 2, 3, there's someone standing right here. I feel like that's him because you can see the satchel, his merce, and he's got a dark shirt, so the red shirt, the light colored jeans. But it's like, you kind of, the way he's positioned, he keeps ending up behind this, I don't know, telephone pole, tree, whatever. So here comes Mr. Omar. Okay. Boom. Boom. Hey, stop. Stop. What are you doing? You can't go through our barricade. We're the shit. We're kidnapping the neighborhood. Don't do that. What are you doing? Stop. Stop. We're gonna shoot. There we go. Boom. See right here. Okay. That's him right there playing Rambo. Light colored jeans, red shirt, black satchel, shooting up the car. He probably would have killed Mr. Omar, but Sequoia took that shot. Right there. There's just no way. There's no way around it. And the fact that you just decided to show it again, baby, what? Look, it's time to go. Look at people getting ready to go. It's time to go. They shooting. They just shot up a family car. It's time to go. The lady who was over there at the Black Lives Matter protest across the street, right over here, which that's the burnt out Wendy's. This is where they're getting ready to build the BP that sits there now. She saw the whole thing and wants to pretend like she didn't see anything. Everybody saw that. That's why those people jumped in the car and are getting their ass up out of there. People started leaving. Even time to go. You see that? It's time to go. I'm going back to the, I'm gonna take it on to the house. Look at the people crouched down. Get your tent. Put out the grill. You got your stuff. It's time to go. Okay. Just be cool. Just be cool. We just gonna go ahead and go in a minute. Look at that. They're like, I'm out of here. I'm gonna see y'all later. Peace. Look at this. This sure was okay. That's them, right? That's Mr. Omar. When after they shot out the wheels on his tires so he can't get to the hospital. They shot the wheels out on the car. Is that them going back through? Yeah. Look how he's having to drive, no tires. Because whoever genius shot out the tires. So they can't get the baby to the hospital. If that's the car, I think it looks like it was wobbling. On top of shooting the little girl, you shot out the wheels so the parents couldn't get to the emergency room fast enough. So nobody's guarding the barricade now because they're going to go. Where's the place? Elmore, where 24 shots got fired, 16 people, 2 people died. Was it 16 people got shot and 2 people died? Some of the people from over here went over to somewhere else. 2 people got killed. A bunch of people got shot. Mr. Conley says somehow his gun got stolen out of the car. His gun got stolen over at Edgemore or wherever that other place was. Forgive me for not remembering. But there was another incident that happened 4th of July night, and he said his gun was in his car. Someone stole it. But all those guys dispersed to somewhere else. It was so important for the barricade. Now it's not important anymore to have it. Cars are driving through. Look how fast they're driving through. People are scattering. You see this? They're trying to find where to go. They know something happened. I feel like they were shooting. Weren't they stopping people up there by the package store? So I feel like was that a second set of barricade? Because weren't they stopping people right up there at the package store? The package store and Wendy's right there. So this was this a second set? Because they were already walking down to shoot this guy right here. I don't know if he shot or not. When they show that guy, those are the people in the burnt out Wendy's parking lot up there. That's the package store right there. This is the yard of that warehouse, and they're coming down and around, and they show this guy, but that's not the right vantage point. The SUV, I feel like, clears somewhere around here, because notice how there's no traffic turning around. There's traffic here turning around because they're coming from the opposite direction, and they're not letting anyone go through between Wendy's and the package store. So if you're coming from off the highway, you had to turn around. And if you were approaching from the opposite direction, you had to turn around. So right there in the middle was the no traffic zone. So when they cleared this zone, this doesn't tell anything. They're showing this to confuse people, because the SUV had already cleared the first set of barricades right there. That's the people walking down the middle of the street already shooting. I don't know if he shot or not, but if he shot, I don't know. It doesn't make a difference. Sequoia could have already been dead. Well, she could have already been hit. You see what I'm saying? That guy back there is not even relevant. The car probably had already been hit from these guys up here. That's what I'm saying. It's a different vantage point. They had already gone through. There was another set of barricades a little bit further up. Right. This is further down. Wait, where are we? Right here, 51. And then this is where the shooting took place. That's Wendy's. Is that the Wendy's? Yeah, that's the Wendy's. We'll have to look at the daytime map, because yesterday it was so much more clear looking at the daytime map to match everything up. Anyway, let's get back to here. So Get it back to around here so you guys can see the rest of it. He's getting ready to put his red jacket on again, y'all. Look. Oh, Jesus. That he came speeding through because he was trying to get the baby to the hospital.
I'm going to finish like I started. I guess had I gone to a Wake Forest game and watched Mr. Body's brother in their black and gold, perhaps I would have stood out in my red, but I didn't at the game I went to. Or perhaps had I been on that University Avenue that night, I would have stood out. Or perhaps if Julian had been in that red and white actually doing something, he would have stood out, but he didn't. I hope you got a good look at the video at both of them. I hope you saw community. I hope you saw kids, small adults doing cartwheels. I hope you saw that guy walking his dog. I hope you saw the grills and the smoke. I hope you saw families. They were there for community. They were there to uplift their community. They were there to love their community. And because they're abandoned by the city whose job it is to serve and protect, the city left them unserved and unprotected. They were there to serve and protect their community. You heard Ms. Salloway. Every day they were providing food for people. They got in the bathroom. They were going to get 2 showers that day. Salloway planted a garden. They were there for community. There was no meeting of the minds to take over. This is blood territory here. The only game Ms. Salloway was in was a game that loved her community. That's all they were there for. There was no meeting of the minds. There was no, let's block this street. Let's show our dominance. Let's show our conscious and deliberate, intentional. Let's show dominance. They never showed even who put the barricade there. Because they abandoned that area. Yet they come in here throwing words around like gang and armed militia. And all they have is shepherd. Shepherd is their shepherd. He told Agent Coleman what he wanted to tell Agent Coleman. He showed Agent Coleman what he wanted to show Agent Coleman. He put circles around that video so that you will look where he wants you to look. We don't even see the whole McCord interaction if it happened 2 minutes before this. We don't see that. So clearly there's a blind spot in this video. Clearly there's a blind spot in his heart. When I think more about that second video you saw at the last barricade, and you saw that car go by, and you saw the person kneeling or squatting, and you saw him creep behind the barricade, Shepard had an answer for that. Oh, he was ducking for cover from Julian Conley's fire. to you? Well, I have news for you. That's not even what it looked like to him. But when you rush to justice by rushing to Julian, you don't really care about truth. Now, the way the rules work, I don't like these rules. I have to sit down. I don't like that. I'm scared. I'm scared like I was last Wednesday. I'm scared now because once I sit down, no matter how much I want to, and I'll be sitting right next to Julian, no matter how much I want to, and no matter how much he wants me to, or his family, they want me to, I won't be able to get up again and say another word to you. They will, and that's why you see them typing furiously away, because they're typing real time a response to everything I say. You didn't say that right, you didn't say that right. Oh, I got you on this one, I got, aha. The rules don't allow me to do that. The rules don't allow me to answer their questions or question their answers. The rules tell me I have to sit quietly because they get the last word. Except they don't. You do. You do. You get the last word. You get to tell them. You don't get to rush to justice by rushing to Julian. You get to tell them when the mom and the man behind the wheel all agree. So it should be you. You get to tell them that. You get to tell them that that girl's life is worth more than an 8-day investigation. You get to do that. You get to tell them, you see those pictures he gave you with those 2 people circled? How come you didn't look for those people? How come you didn't look for those people? How come you didn't do a bulletin with those people on it? You get to tell them that we live in a day and age where you can cheat on your wife at a Coldplay concert on Friday, and by Saturday morning, the world knows your name and her name. You get to tell them to do more. You get to tell them that girl's life was more than 8 days. You get to tell them that her life was worth more. You get to tell them with the t-shirts and the placards and all say Black Lives Matter, her life should matter. You get to tell them that. You get to tell the city of Atlanta, you don't get to wash your hands of a community. So just as my dad got on that plane and that boat and went to Vietnam to fight for the thing that we call justice, for the thing that we say we believe in, and I know you do. I know you do. You don't have to get in that plane or that boat and go to some foreign land and set foot on some foreign soil. Sometimes you get to get a jury summons. Sometimes you get to read that jury summons and say, oh, hell. But sometimes despite saying, oh, hell, another one. You come here and you sit through 2 days of questioning and thinking of, what do I say to get out of this? But sometimes you end up sitting in that seat where you're sitting right now because you get to apply your common sense and your reason and your life experiences. Without going to Vietnam, just by getting in that car and coming here and getting on that shuttle and walking into this building and sitting in those seats. Some of you are already, but you're all veterans now. You all get to fight for justice. You all get to tell them You all get to tell them. Should have been more than 9 days. You all get to tell them. You don't get to rush to justice by walking or rushing to Julian. You now get to tell them that by finding Julian Conley not guilty of all charges. I thank you for your attention.
Before the next argument, which can last a little over an hour, do you need to take a break? About 15 minutes? 15? 10? Okay, 10 minutes, guys.
All right, for the jury.
Okay. 10.
Yep. I mean, this is the deal. Somebody knows something. You two, y'all, it's gotten to the point where I'm like, stay out the window. Oh, these dogs. Anyway, it's ridiculous. Somebody knows something. Clearly, someone saw something. A lot of people saw what happened. They know exactly who did what, but also keep in mind people were hanging out and they know who was hanging out relatively as well. So, and then even though they didn't show somebody's face, that lady, Arnold's over here saying her name. I don't even know if we knew her name, but we know her name now. Somebody does. She showed enough to show she got long locks. She says she has a wife. So she gave some attributes about herself that people might be able to think back. Oh, okay. You know what I mean? So I don't wish her anything, but if it's a dangerous area and people are retaliating, then people might feel like they have to be careful and stuff. Yeah. So she was out there for a month. She said she was out there after Rashard Brooks situation up until the middle. So she said the whole summer, but that would sound like it was about a month, like the middle of June to the middle of July. They were outside camping, hanging out all night, doing whatever they felt like they were doing. I don't think she said she had an AR-22 or 23, something like that. She didn't have an AR-15. And her nonprofit, she said they were going to get a peace center. They were going to convert the Wendy's into something. I'm like, lady, the city council doesn't have anything. City council is going to buy those people's property for you. Because that property does belong to whoever owned that Wendy's. We're gonna see what happens. She didn't read the directions yet. She read, oh, you know what? Look, we're sitting here and girl, we got time. Okay, hold on. Let's get our time back. What are we doing? Okay, guys, are you guys back in your seats? Let's go.
Long years.
His Arnold's closing was horrible. Hold on. His closing was terrible. It was terrible. Just rambling, right, Miss HLS? Just terrible. The jury said, can you make sure Mr. Arnold doesn't get back up again? Okay, I'm going to see what I can do.
I'll be watching.
The jury said, no more Mr. Arnold, please. Lord, don't let him back up.
Mr. Regis is absolutely right. I am over there typing feverishly because at that table, we carry the responsibility and the burden of making sure that we bring you absolutely every piece of evidence to prove that this defendant is guilty beyond a reasonable doubt. And I take my responsibility serious because it's important. This matter is important. It's not a joke. It's serious because an 8-year-old little girl is dead. So I'm going to apologize in advance if I repeat myself, if I go over stuff that Ms. Rabati may have gone over, but I don't want to miss anything because I don't get a second chance to ensure that Sequoia gets justice, the justice that she deserves, the justice that her family has been waiting on for 5 long years. Now, Mr. Regis talked about failures. I'll tell you what the failures are. The failures are over there at that table. The failure to take responsibility for what the defendant has done. He wants to put the blame on everybody else except for where it should land, and that is on his shoulders, nobody else's. He talks about the police weren't there. Well, what they don't want you to know, the police weren't there because the police were the ones that were in danger. They were supposed to be out there protecting the community, loving the community. But in all actuality, they were terrorizing the community. The police were their target. So the police said, you know what? Let us back off. Let us give them their space to allow them to express themselves however they want to. But then it turned dangerous. And the police had no other choice but to come. So don't make them think it's the police fault that he decided to pick up an AR-15 and shoot and kill an 8-year-old little girl. It's not the police's fault. It's Julian Conley's fault. Omar rolled back through the barricade. Now he kind of glanced over there because it would look crazy to blame a man who was driving an 8-year-old child who was bleeding to death in the backseat of a car. So he wanted to glance over that. But Omar said, I didn't know what to do. But you know what's the closest highway to get to? You got to go back through there. Otherwise, you got to go all the way around to Hank Aaron to try to get back on the highway. He was trying to get Sequoia to help as soon as he possibly could. Detective Shepard, and this is repeated, a rush to judgment, a rush to judgment. What did he tell you? I followed the evidence. I followed it, frame by frame, hour by hour, minute by minute. And you know where it led him? To Julian Conley. Now let's talk about when the defendant showed up 9 days later, because I want you to make sure that's the map. When Detective Shepard took out those warrants, that's because Julian Conley showed up and said, it's me in the red shirt, it's me in the light jeans, it's me with that AR dangling in between my legs. Because he already knew he was responsible. But did he take responsibility that day? Oh, absolutely not. So when you want to talk about 9 days and a delay and justice, it don't land with Detective Shepard. It lands with Julian Conley. Because he knew from day one. I'll give him day 2 when the news came out. Because he was too busy over at Edgewood on day 1. Lies and exaggerations. There's lies and exaggerations over here. But it don't come from the state. It don't come from the witnesses that the state brought to you. It comes from the defense witnesses. And we'll talk about that. He a dumb 19-year-old and he's in a gang. That ain't an excuse, ladies and gentlemen, to gun down a car and kill an 8-year-old girl. I have a 19-year-old son. It is unacceptable. He came from a family, law enforcement, so you know better, so you do better. He chose to do what he did. And therefore, he should hold and take responsibility for what he did. And not just try to say, oh, I'm 19.
So when Arnold was sitting over there testifying and nobody objected in his theatrics, his shenanigans, now she's putting the smack down. He's mad. Girl, I'm eating my salt and vinegar chips like, wait, hold on. Girl, I'm eating my salt and vinegar chips like watching the closing. Okay. I'm like, ooh, I just made myself a fresh iced tea and some little salt and vinegar chips. I am all into this closing. I wanted to get some fish too. Girl, they have the nerve to object. The trickery. He called his client a stupid kid.
I'm going to remind you that the state has the entire burden of proof. They've got to prove each and every element of each charge in the indictment beyond a reasonable doubt. There is no burden whatsoever on the defendant, and that burden never shifts to the defendant. Go ahead.
Being 19 is not an excuse to kill an 8-year-old girl. They talk about half-truths, lies, dangling off of Detective Shepard's tongue. Well, what they got up here and told you, Mr. Regis, he got a difficult job. I had Mr. Regis' job at one point. And I went to a training, and what the trainer told us in the criminal defense advocacy is, if the law is on your side, argue the law. If the facts is on your side, argue the facts. If the law and the facts are on your side, argue them both. If you don't have either, just argue. And I submit to you, ladies and gentlemen, that's what Mr. Regis did here today. He just stood up here and argued and said anything, because that's what he got to do.
Girl bloop, okay?
But
No,
he,
she did not just, she said that. If you don't have anything, you just argue. Okay? Argue.
he wants to tell you there's kids doing cartwheels. I want y'all to think back and remember the context in which Miss Broderick was showing those children. She was talking about who in the red shirt is shooting. Who in the red shirt got a gun when she pointed at those kids. That's what she was talking about. Don't let them give half-truths to make it seem like that we're glossing over that there were other kids out there. There absolutely were kids out there. Kids that were also in danger. And thank goodness they were not shot and killed too. They failed to mention that the kids had to duck down as those shots are ringing out. Because I hope y'all saw them running, scurrying, running behind cars and hiding. That's what this defendant's actions caused the children out there to do. And then we showed you a portion of that video. I hope y'all remember because we played them over and over again, zooming in, zooming out. On that other side where that Williams tent was, gunshots firing all over the place, still in the middle of the road, even after the Jeep has passed by. At no point in time has the state argued that there was only one person out there shooting. It was multiple people out there shooting. This defendant just happened to be the one who got caught. The McCoys didn't see the gun. They don't have to see the gun. When you get that indictment back there, you will read it and it will say guns being pointed in the direction of them. It doesn't say they got to see it, they even got to know about it. But we do know they know about it because we're at the barricades, and unfortunately, that video was not done right before the time that they got up to it and went inside. But you know, and we've seen that car pull up to that barricade, is down in there for about 2 minutes before they pull out and pull back into the package store. So actually, they were victims of aggravated assault twice. Inside the barricade and in front of that liquor store. Party to the prom. They just went off. We gonna ignore that. We gonna act like it don't exist. We gonna fail to mention that. Because if they mention that, they gotta tell you that the defendant is guilty. Beyond a reasonable doubt. Because what did Detective Shepard tell you? He didn't have to be shooting. He says he was out there, he was at the barricade, they're all acting in concert, they're all working together. Therefore, even if he did not fire that gun once, he would still be guilty of murder, felony murder, and all the other charges that he has. But what y'all know, because y'all have common sense, which they want y'all to check at the door, but I ask you don't check it at the door. It's the defendant, his shots, that went into that car and killed Sakori. Now, we went back and forth, we pulled up chairs, we rolling back and forth, talking about the path and the trajectory. I ain't hear none of that today. They just failed to mention it, they just abandoned it because it don't make sense. It doesn't make sense. And camera 2, there's no zooming in of the shooting. We sat here for almost 10 minutes watching that video. At no point in time do they zoom in and say, you see where the muzzle shot's coming from? That's the man in all black, because they can't tell you that because you have common sense. You've seen this man walk around with his white jeans on and his red shirt, and you know that it's him behind that barricade, stepping out with that AR, pushed forward, pointing at that car, and he just starts to blast, like the rap song say. And then, just no remorse. Y'all heard that before this even happened, the defendant is out in Cobb County committing acts of violence, endangering people on the highway, throwing smoke bombs in the middle of the highway where a woman is driving with 3 children in the car with her. Thank goodness that she didn't wreck and get hurt or anybody else on that highway. Then you get to July 4th, still behaving as a gang member, walking around, terrorizing the community, day in and day out. Then after that, he had over to Edgewood, still with his AR-15. And 9 days later at that press conference, want to talk about lies. Lied. Over and over again. He's 25 now. He in the jail still, wiping his nose, throwing up the gang signs with people behind him with shanks. The age is not an excuse. So let's talk about the facts. And ladies and gentlemen, I do not at all look past the fact that there were people out there for the right reason. There were people out there wanting to use their voices to combat the injustices that they believe was going on in not only in the country, but right here in our city. And they had a right to do that. Miss Salloway, by no means do I think that she is part of the gang that Mr. Conley belongs to. But see, what happens is that they were out there for good reasons, but these individuals, being Mr. Conley and his crew, came out there for the wrong reasons, and as a result of that, a child is dead. They want to blame it on the commissioners, they want to blame it on the police, they want to blame it on anybody. But the commissioner's not out there with no AR-15s. The police aren't out there with AR-15s. It's the defendant and his crew. And that gets overshadowed. Because I do think that Salloway, nobody's out there spending the night, overnight, taking showers, from going home, using the bathroom out there, dedicated to the cause and to the mission. And we are by no means saying that was anything wrong with it. What was wrong was the behavior that these defendants took, this defendant took, that does not go with this group. There are various different groups out there. You got the gangs out there, you got the protesters out there, and you just got the regular citizens that's just trying to live their life. They trying to get gas, they trying to get a couple of chips from out the store, but you got these folks not even allowing them to get to their homes. And we're gonna talk about that. They want to tell you it was festive, and it may have been festive. I didn't see that videos, but I don't call it a festival when folks walking around with AR-15s and handguns and following people and making them turn around. So maybe there was some bouncy houses, I don't know, but what I did see was barricades that was blocking off the street, did not allow people to get where they needed to go. There was upliftment and love for the community. That don't look like upliftment and love for me. If you can't get where you need to go, if somebody walks to your car and you're saying, I just want to get home, and you're met with a gun to your face, telling you get back in your car and turn around. They were serving and protecting their community. They killed a member of their community. That's not serving and protecting. They were out there for healing. Well, it ended up in harm. And kids playing, so they want to say, ended up in a little girl, Sequoia, being killed. It was Independence Day, ladies and gentlemen. There was nothing independent about what was going on the corner of University and prior that day. Nothing at all. Those people they were like, I don't know, prisoners in their own community. You can't go here, you can't come up that way, you can't go down that way. Luckily, I don't know, the bus, hey, Mr. Bus Driver, we'll let you go. But there was nothing independent, there was nothing free about those moments and those days over there. And it's not fair to the people that were out there for the right reasons. And what are they gonna do? They gonna tell them folks to leave? They got a whole crew out there, ganged up, ready to go, because we see them every time Mr. Conley's moving, they moving with their guns pointed and ready to shoot. But we'll talk about that. And they're exercising power and control. Now, they say Black Lives Matter. We're about police brutality. And ladies and gentlemen, the evidence is real clear. It wasn't the police that the community had to be worried about out there. It was the defendant and his gang members. And the most precious and innocent Black life was lost because of them. And Mr. Abadi kind of touched on this, what was the motive? And that goes all to the gang stuff. You're going to do what I say when I say do it. I told you to turn around. I told you you can't come through here. And when you don't do what I tell you to do, then I'm going to let my gun just ring. And that's what he did. And we'll get to why I think he believed it was the McCords because of the time period. And I just told you, don't come through here. And you got the audacity and the nerve to turn around and come back through here? Oh, I'm about to show you. What did Charmaine say? She heard him say, hey, like that, stop. What did Omar say? F-ins, as they're trying to just go home. Even their own witness says, she heard them as the car is pulling up. Hey, once again, trying to stop a citizen from going to and fro about their own business in a place where they have the right to do so. But until this defendant and his crew decides we're going to block it off and we're not going to let anybody do it because they were illegal barricades. They had no right, they had no authority. Anybody had the authority and the right was Omar. He should have been able to drive through that street without having to go up on the curb, not being in fear for what's going to happen to him and Charmaine and Sequoia in that car. So let's talk about the evidence that proves this defendant's guilt. You're going to get evidence, and you've got evidence through witnesses, the physical evidence, scientific, and even the admissions and the words of the defendant himself. And we talked about Aiden Coleman, and Mr. Rakes has already said, hey, yeah, he was in a gang. He was 19 old, just excuse it. He didn't really mean it. But he's still doing it. He's still practicing and acting up with the gang. Miss Duffy, and we talked about that in Cobb County. Intimidating looks, his red bandana and mask. Remember she talked about the smoke bomb being pinkish or red. Loaded down with guns and ammo. What did Officer Brazanga tell you? I'm on duty and I have about 89 to 100 bullets. He walking around with over 1,000 rounds of ammunition. Because he ready for whatever comes along, he gonna take out whoever he wants to. And Mr. Reagan got up here and said, oh, Jasmine Duffy got up here and she got up and said, because the state's telling these people to do this. Oh, that's it. That is not what happened. She looked at the booking photo and said, yes, that is the man who looked me in my eyes and then threw a smoke bomb under my car while I had my baby and my nieces in the car with me, putting our lives in danger on that highway. And Howard Point bullets, the most lethal bullets there are. That's what he carrying in his book bag. And the AR-15, well, that belonged to his friend, one of his crew members, one of his gang members that just took responsibility because he was already getting ready to be arrested, so we can't let them take that AR-15. I would submit you that AR-15 that they got in March is that same AR-15 that he had out there in July. Mr. Reagan wants to tell you that, oh, he's not the leader because they weren't posting. What did Ms. Salloway tell you? We didn't have to post. There were no chats going on. We knew to be out there. We showed up, and day after day, we would just come. So he ain't got to post. He ain't sending out invitations like he inviting folks to a wedding. They all just showing up to run the streets. But he did post, go burn down Cobb County to get my property back. I need my guns and my ammo. He wearing his gang outfit all and through there, and we'll talk about that. He gets to decide who goes and comes in the barricades. I hope y'all, and I know y'all probably tired of looking at the video, but if y'all want to look at it, y'all get to look at it again. But there are times when you see that defendant with his red shirt on, with his white letters, moving cones, moving barricades, swinging, hey, waving people through. He is in charge, forcing people to turn around at gunpoint because he decides you can't come through here. He told them, of course, turn around. And some people, they got into the barricade. They saw what was going on. We just gonna turn around. We don't even want that smoke. And just minutes before, probably not even minutes, I hope y'all saw that white car before the Jeep comes. He walks out of the shadows. You see that white lettering on his back. He goes up to that car, and that car just turns right around. Because sometimes you don't even have to point your gun. Because I'm telling you, if it's AR dangling between your legs, I'm moving. Don't worry about it. I'm gonna turn around. And he's giving directions. I know it's hard to hear, but that older black man looks at him, the leader. It's good. And he said, oh yeah, he good. He can get on. He is in charge every step of the way. He gives directions to the MARTA bus driver. At the end, when they finally let him through, he walks all the way down to the end of the barricade, and he's waving. Come on, you can come through. Not no other person. Not no man dressed in all black. Not no man dressed in, not even Mr. McKinney with his white shirt and black. It is that defendant giving directions to everybody. And I hope y'all know he's standing at post all day long. That was his post, the barricades. Because they had certain points. If you saw, Mr. McKinney was over at the BP station, and Mr. Conley stayed at the barricades. And we know he had the barricades because he tells you in his press conference he was at the barricades. And when the Jeep pulls up, he approaches. He leading the pack because he in front. He is in front with that AR pointed, and he begins to fire, and the rest of them follow suit. Because I hope y'all know, is there a man in all black shooting? Yeah, but when does he shoot? After his leader. And not only does he step up, he follows the car all the way, and the physical evidence will show how he followed that car as it passed by, trying to get out of danger. Leading, standing post. Telling his crew where you need to go. I don't know if the McCoys went where I told him to go, McKinney, go back and check. I hope y'all look at that video and watch Mr. McKinney run back around to the other side of that package store to do what his leader has told him to do and make sure the McCords are gone. And then he comes back and goes and checks in once again with his leader. He's not just a gang member, he is the leader. And we know he had guns just all day long. And how y'all know it's him? He got the same light jeans as he did on July 4th. Credibility. Now, the judge will instruct you that it is your responsibility to judge the credibility of witnesses, and yours alone. So you get to decide who came in here and who told the truth. I submit to you that the state did not put up anybody that told you anything but the truth. Now, they want to call Detective Shepard a liar, and he's not a liar. They just mad that the evidence that he got led to their client. What did Samantha and Christopher McCord tell you? They pulled up to the barricades. Mr. McCord describes a light-skinned male with a long gun. Now, I mean, it was a long gun. That gun looked really long to me. He didn't have to say it's a rifle or not, it's a long gun. He forces them to turn around, and then he gives them instructions. And then Mr. McCord, after seeing this defendant admit that he was down there, he says, that's the dude that met me when I was inside the barricades and told me to turn around. And how we know it's him that met him at the barricades? Because he follows him after he turns around. There's no doubt who that is. And I know y'all was probably tired of hearing about Sage 112, light jeans, red shirt, but we got to prove it. I have a responsibility and a duty to prove to you beyond a reasonable doubt that it is that defendant that committed each of these acts. And so if I got to tell it to you over and over again, I will do it over and over again because this is my one shot. Aggravated assault, like I told you, twice. Now, Mr. Reagan's talking about somebody squatting down ready to shoot. It was his client, ready to shoot. Now, Charmaine Turner, she told Detective Shepard everything she could. Not one time did she lie to Detective Shepard. Were there men out there with black shirts on, dressed all in black, dressed like the police, dressed like the militia? Yes, they were. Were they all armed? Yes, they were. Were there men in all black shooting guns? Yes, they were. He says we didn't ask her the question about whether or not it was the defendant that shot Socorro. We didn't ask her because she said, I don't know who shot my child. I just know my child was shot as I passed through a barricade with armed men. And who would expect her to know anything else? Because he started with the mother. The mother in the back of that car. First of all, she said, I'm on my phone. So Corey's back there on her phone. Next thing I know, fire is coming into the car. I reach back to get my child. And the last words I hear my child say is, Mom, crying out in agony and pain. So he wants her to be able to tell you about a red shirt. The only thing red that she was concentrating on was the blood that was pouring from her baby body. And she tried to press on that wound to keep her baby alive. I'm a mother, and I know what that feeling feels like, to hold your child the first time they take their first breath, as their heart beat for the first time. I can't imagine the anguish it feels to hold your child as they take their last breath.
Objection, Your Honor. May we approach?
If they don't have anything, they just argue. Just argue. What do you have to argue about? She's holding her child until the last breath. Is that hearsay? I mean, come on. What's the problem? He put on 5 jackets and put on a whole damn carnival show, and nobody stopped him. He can't let the lady speak.
She's focused on her baby that is dying in her arms. So it is not fair for him to say, because she cannot point out this defendant, because we ain't got to worry about her pointing out. The video's pointed out. And didn't I tell you 2 things to be true at the same time? Could there be men in all black shooting? and this defendant shooting? Absolutely, and you know it because it's on video. Omar, it's men in all black. They bounty hunters. He gave a picture to Detective Shepard. Yes, he did, because Omar is like, y'all, that man is driving that car. He made the decision to drive through that barricade. The responsibility on him weighs heavy. Y'all can see it on his face. So he is doing whatever he can, giving Detective Shepard whatever information he receives about who could have been the people out there that were shooting into that vehicle. He never said definitively that man didn't shoot. He never said that. What he said was it was men out there dressed in all black that were shooting. And is that true? Yes. Was the defendant out there shooting? Yes. So two things can be true at the same time. Don't try to put the onus on the man behind the wheel. The man behind the wheel was trying to make a decision in the most traumatic event he has probably ever experienced in his life. What do I do? Where do I go? Because when you pull up to that barricade and you see them people, you got to make a decision. And we came Monday night quarterback, I guess it's Tuesday night quarterback now since it come on Monday, to decide if you pull up to a barricade and you're trying to drive through, it's armed men in front of you. You don't know what they may do if you just turn around. So I'm just going to push through. And there's nothing wrong with that. He was trying to be a protector. How can I get them to safety as quickly as possible? We can't blame him. The blame lies on the person that pointed that AR-15 at that car and let off 8 rounds into it. We lucky it wasn't Charmaine, Omar, and Sequoia. And what did Omar tell you? I wish it was me. That's who's taking responsibility. And he said, I'm going to get an attorney. There's nothing wrong with that. He's like, I'm driving the car. I want to make sure that nobody thinks that I did this. I'm responsible for it. Because I don't know if you heard the little tricklings of, oh, the person in the car was shooting too. So he's trying to make sure I'm protected. But what he does say is black men and all black were out there shooting, and we know that to be true. And we also know it to be true that the defendant was out there shooting. Now, the defense witness, Ms. Salloway, like I said, I think she came with good intention, or at least she was out there for good intentions. And she was trying to do what she could to help. But the things that she told us was real important, and it was consistent with Omar and what Charmaine told you. As the Jeep pulled up, I heard somebody yell out, "A." The Jeep went up on the curb and shots rang out. And she told you, as the Jeep passed by, I saw shots in the back area behind the Jeep. And the windows of the Jeep were rolled up. Now, what she get a little fuzzy on her credibility is that the man at the back barricade was shooting. Well, ladies and gentlemen, y'all get to view the videos. Y'all get to decide. There doesn't appear to be muzzle flashes. She said she didn't see muzzle flashes, but she thought the man was shooting, but she really couldn't tell us where she was standing in the Wendy's parking lot. And then at some point, she started saying, well, I heard what happened. So I don't know if she heard it that night, heard it since this trial has been going on, and feels like that's what I saw. But to me, that's just a little red herring. But what she does tell you is the shot, as the Jeep returned, she heard some more shots. She don't know where they came from. They don't know who they came from. And I think she said, Mr. Raines wants to tell you that the man was not ducking for cover. That's what his witness said. He ducking down. He moved all the way to the other side of the barricade to avoid the shots that this defendant is firing out in his directions by the barricade. She tells you men in black are shooting. Absolutely, they are. But what she didn't tell you, she never said that defendant didn't shoot. And what, in fact, she told you he did, but we'll talk about that. And now it's Detective Shepard's fault. Detective Shepard told you I was working 12, 14-hour days to figure out what happened to this baby. I'm canvassing the area. I'm trying to get people to talk to me. I'm not getting any cooperation. The people that are talking to me, it's exaggerated for what they're telling me, because when I look at the video footage, it's not corroborated by what they're telling me. I'm getting information from social media. He never denied that there were men out there shooting in black. In fact, what did he tell you? If I could have identified them, I would have put a bolo out for them. But I didn't have any identifying photographs where I could see their pictures, their faces clearly, to put out on a bolo. He never got a positive identification for them. The only two people he was able to get a positive identification for was the defendant and Mr. McKinney. And when he got those, he put it in a bolo, put it out there, and he got those individuals to then come in and say, yes, that is me that you see. And we know that he's not in a rush to judgment. Because what did he tell you? I didn't charge McKinney. Because as I'm looking at those videos, McKinney is not at the barricades. So I'm not just out there trying to charge anybody that I see with this homicide. I want to make sure that I charge the right person. Because I have all the evidence to show me that it is that person. So it's not a rush, ladies and gentlemen. He's following his evidence. And thank goodness for Mr. Camber, because when we were able to get that video from Martin West. We were able to get those clear images. And if you recall, there are other images as that bus is turned around on the side where there are other men out there with guns and they got them posted, they got them pointed up, but you can't see their faces. So you can't put out a bolo for somebody whose face you can't see. Then he told you those are muzzle flashes. At least 2 we see as that Jeep passes by. And what did he tell you? I didn't know. I did not know who my suspect number 1 was. I knew what he looked like. I knew how he walked. I knew what he was wearing. I just didn't know his name. I didn't know his name until he showed up with his attorney and said, that's me at the barricades. And then Mr. McCord then calls and says, hey, yes, I recognize that man as being the person that pointed a gun at me. And lo and behold, what do we have? Video footage of that defendant pointing a weapon at Mr. McCord and his wife as they drove away. So it ain't just believe Detective Shepard. Everything he says is corroborated by evidence. And Miss Cassandra Salloway, what did she tell you? She identified that muzzle flash as that defendant is standing in the middle of that street, firing off. And what did she tell you? The jeans are so light, they blend into the street. Who is the only person out there with light jeans on? Because everybody else is smart enough to wear all black, except for the defendant. So even their witness has identified the defendant as being the shooter out there. Black do-rag, his twist, his light skin, his red t-shirt, his light jeans that we know belong to him because he had them on in another picture with another gun, his black bag, his black shoes, and his gait. What did Detective Shepard tell you? The way he was walking, and y'all saw he's kind of walking kind of funny because of that gun. It's messing up the way that he walks. So that's how he's able to follow him from the BP, from the package store to behind the barricades. Every step he's made is distinct. He decided he wanted to be seen because I'm going to rep my gang. I'm going to put on my gang t-shirt, Pyro, Elm Street, Pyro, whoop on the back. I want to be seen. And he was seen by each and every one of those cameras out there. And he was seen shooting at that car and killing that baby. Don't leave your common sense, ladies, at the door. You've watched the videos over and over again. Believe what your own eyes tell you. Miss Young, if you talking this, trust the videos. You've seen them enough. If you want to see them again, you can. I think Mr. Body said it out. We didn't even coordinate on this. Context clues. Those are important. I had a son, he was real younger, and I said a word, and I said, how do you, and he said, oh, that means such and such. And I'm like, how do you know that? He said context clues. Ladies and gentlemen, use your context clues when you get back there. Red shirt, white lettering, light jeans, black satchel, AR-15, funky little walk because of your AR-15, your light skin is your twist, and who you come up with. At 9:45:21, this defendant is standing at his post. Light jeans, red shirt, black shoes, black satchel, light jeans, red shirt. You can kind of see that AR hanging down right here. Black shoes. At 9:45:21. At 9:46:02, less than a minute, that Jeep is pulling through. He has not moved. You saw the videos. At no point does he leave from those barricades. The only time he leaves from those barricades is when he steps to that Jeep as it pulls through. And here he is again. AR extended. How do you know it's him? Them light jeans, them dark shoes. You can kind of see it in the red, but it's dark because if you all know when you take pictures, if the lighting is behind you, it's going to be dark. That's why kids always tell me, get the light, you got to get the light so you can make sure your colors pop. But it's enough for us to see it ain't the man in black, ain't the man in black, ain't the man right here, light jeans, dark shirt, AR. And what did Samantha McCord tell you? If you point a gun, you ready to shoot a gun. Not less than 5 minutes later. I hope when we gonna go through the timeline. This is what he doing. Pulling his gun. And when that car comes through, 2 to 3 minutes later, he is ready to shoot. And that's exactly what he does. And I know it's blurry, ladies and gentlemen, but you can, I hope you can see it enough. That's him. Go back. And where are these other men? They're back here. Where's the Jeep? Tracking his every step. That's him, ladies and gentlemen. Now, when Mr. Radius got up here and showed you this video, he didn't want to zoom in this close. Because if you zoom in this close, you get to see his client committing this murder. The physical evidence in this case, ladies and gentlemen, because we're not just going to bring you the witnesses, we're not just bringing you the video. Does the physical evidence show that this defendant is guilty? And we talk about these videotapes from every angle, not just one angle, not just a half an angle, every angle, tracking him so you don't have to wonder, is it him? Did he go somewhere else? There is no doubt it is him each and every time. Nine 12:45. Nine 13. Nine 13 50 seconds. Nine 15. directing the marshal, telling him where he can go. (9:38). Back at his post. Moving the cones. Moving in on the McCoys, because they have challenged his authority. (9:40). Every minute, every second. The defendant is present and making decisions as he's terrorizing and victimizing people in the community. I hope y'all see Mr. King. Go that way, and he goes. 9:40. 9:45, 24 seconds. Just seconds before that Jeep comes through. You can't miss him, white lettering. One shot, two shots. And we show y'all, it's another man in all black shooting. We're not trying to hide from it. Because it doesn't matter, everybody at that barricade is responsible for Secoria's death as a party to the crime. What's the physical evidence? Defendant there before, during, and after the shooting. What's the path of those bullets in that car? All on the driver's side. Now, Mr. Raby's starting to talk about path and trajectory and when they have to come from the right. None of it makes sense because all of the defects are on the right side of their car. The muzzle flashes that you see coming from that defendant's gun, when the police get out there and they find shell casings right there in the area where he was standing, where he was firing his shots. 6 shell casings, 7 of them. How many defects in that car? 8. And we saw the pickup man coming by picking them up. So maybe he was lucky enough to get one of them shell casings that came from the defendant's gun. Driver door, back driver passenger side door, bottom of that passenger door, the side panel. So we know that the shots came into that car from the left. That's what the physical evidence tells you. And then those last two, and I will submit to you, ladies and gentlemen, that last fatal shot came through marker number 8. This is the passenger side, and you'll have the pictures back there that you can look at. They try to say, oh, well, isn't that maybe some bullet holes? It's dirt, ladies and gentlemen. Through that back trunk, through the back panel of that seat, through the seat, into Secoria's back.
Objection, Your Honor, may we approach?
Yes. Okay. We've just stopped because part of the video creation was starting to show. There was an immediate objection. Objection is, go ahead.
Now, that's evidence that is kind of that's nonsense that we have never seen before. We have never vetted. Perhaps we should have kept our expert. We've not had our expert look at it to gauge whether it's representative of anything. It's just something that, again, that we have never seen this demonstrative, and we've had no opportunity to vet it, to check for any scientific accuracy, or to see if it's even representative of anything, to determine whether the jury should see that. So as it is right now, the jury is seeing a piece of evidence, because that's what it is, evidence that has never been shown to us before. We move for a mistrial, Your Honor. We can't undo it. The jury saw it. The jury saw the representation, the 3D animation. It's improper.
Okay, let's see. First of all, can we look at what it was? And I'll say that we saw just the very, very initial beginning of this. So
We didn't see the very beginning of the jury saw the whole thing. Like,
while we were talking it,
while we were walking up there, it was still.
okay. Okay, so to narrate that video, we saw what I guess is your theory of how this happened.
Absolutely, it's just a reenactment. There's no reference bringing a car, and putting a car right there and having it on wheels and being able to move and walk alongside of it, and maybe with a paint gun, shoot at it to hit the doors and the areas in the trunk and the area that the state's evidence indicates where those bullets went into the car. There's no measurements on there, there's no trajectory information, it is just a reenactment of the video that you see as the defendant walks up to the car and it's moving, the car is moving, because Mr. Regis, in his demonstrations that he did during the trial, wanted to make it appear that the car just was staying stationary, it wasn't moving, and therefore his client could be at the back of the car. This is the state's theory, how his client ended up at the back of the car, and those shots ended up in the back of that trunk and then into that baby.
Evidence, I'm sorry, it's new evidence, we've not had an opportunity to object to it, to question the creator of it, to do anything that we would need to, and yeah, case, I don't have a case yet.
Yes, Your Honor. The case of Rickman v. State, that's 304 Georgia 61, a 2018, I'm sorry, 304 Georgia 61, a June 18, 2018 case.
What's the name of it again?
Rickman, Rickman v. State. Demonstrative evidence, which includes reenactments and pictures used to aid the trier of fact in understanding the issues of fact at trial, is irrelevant and inadmissible unless accompanied by a witness testimony that shows the demonstrative evidence is substantially similar to the actual conditions or events at issue.
It's not an evidence, Sean, it's part of a closing argument.
You can't even use your closing arguments if you haven't to put it as in as evidence. The point is, there's a process to how to use demonstrative evidence. If the state literally jumped over and skipped the process, and now they're throwing it in front of a jury to say, this is what happened. These are the facts based off of our testimony. That is not how demonstrative evidence is supposed to work.
Okay, do you, okay, hang on for a second, stop fighting. I'm going to read the case. Do you think that if before closing arguments she had shown it to you and given you a chance to object, that might have been used? Or is your position it had to be evidence in the trial?
It should have been evidence in the trial, but at a minimum, it should have been shown to us before closing to give us an opportunity to object to it being placed before that jury. And we haven't had that opportunity. And we would have objected, but we just haven't had that opportunity to do that now because they sprung it on the jury without ever giving us any opportunity for a meaningful examination of it.
Okay, let me read the case.
Imran, can you make sure you read the coordinates?
Yes. Yeah, if anybody needs to take a break, that's fine.
Oh, this is the arguing trial. This is the we going nitpick. But you know, closing arguments are not evidence, right? The evidence submitted and testimony is evidence. I don't know. I guess it's a demonstrative within the closing, but the closing is not evidence. It's an argument, and they're putting, well, it's not. Yeah, it's basically them stringing together the evidence. The evidence is the evidence. The testimony is evidence. That's what can be considered. The closing argument kind of is a summary of the evidence presented, but it's not, it's not evidence. They can talk about the evidence, but if it's something that wasn't presented as evidence, doesn't make it evidence. it can be based on the evidence, but just because the attorney says it's so doesn't make it the evidence of it doesn't make it like, well, Miss So-and-so said it, so therefore I must believe it. It's an argument. It doesn't mean it's evidence. It's their position of the evidence that's been presented, put together and presented to the jury to consider. The jury can consider the evidence and testimony. What the lawyers are saying is not testimony. She'll read that in her, when she reads the charge to the jury, she's going to explain to them exactly what they are to consider as far as evidence is concerned to make a decision. Ew, I didn't even look, Fit Mom. I guess, yeah, I have nothing for Hoover. Hoover is, ew. Hoover could have the entirety of the Men's Warehouse delivered to his house. I still will feel away. It's still going to be ill to me. Oh, look at us. We have time. I keep forgetting we have time on our side, guys. My bad. My bad, guys. Who's the lady with the blonde hair? Who's this? Is she a clerk? She's one of the clerks. I didn't see her all day. Okay, she's working on the other side. She's like, let me get out of here. They're back at it again. So she pulled up that video. The video started playing, and then next thing you know, okay, can we clear the courtroom? He got mad. I'm sorry. That's so number one, he was at the barricades, guilty. Number two, he pointed a gun at the McCords, guilty. Okay. Oh, they're showing everything he's guilty on. Okay.
Every minute, every minute, every second.
Mm-hmm.
The defendant is present and making decisions as he's terrorizing and victimizing.
They said he had 1,000 rounds. Baby.
People in the community.
And then to me also what's bad is you don't know who anybody is. Nobody knows anybody. Pookie, Juju, Red Bull. You don't know none of these guys. Happy Clown Face. Nobody. Cowboy. You don't know anybody. You haven't seen none of these people. Y'all know who each other are. They were hanging out for a whole entire month. Cell phone numbers, nothing. Argue just to argue. If you got the facts, you argue the facts. If you got the law on your side, you argue the law. If you got the facts and the law, you argue both. If you have nothing, you just argue. Okay, here we go. Okay, Judge. I feel like she's fair. Someone said that she reminds them of Tina Marie. Maybe Tracy Marie.
Oh, it was, yeah. 115. It was definitely 150. Okay, and then 208 is when we started. So let's say Okay, first things first, I want to make sure that we don't steal time from your closing because we stopped repeatedly. It looks to the court like you have about 11 minutes left. Anybody disagree with that? Looks to me like she's got about 11 minutes left. From when we cut off before the, okay. Around 11 minutes too, okay. So that case was close but not quite, and I'm glad you brought it to the court's attention. It's good information. I think under different circumstances in this situation, if the rendering had just been showed to the defense, the court may have admitted it over the defense's objection with proper instruction to the jury. But because it was not offered prior and we didn't have that discussion, I think out of an abundance of caution, we're not going to play it for the jury. I'm going to just give this instruction and you'll be allowed to just continue your argument. A computer rendering of the state's theory of how events in this case might have occurred was played several minutes ago. This was not evidence in this case and was merely an illustration of the state's theory of the case. You are not to consider this computer rendering as evidence in this case. The arguments of the attorneys are not evidence. You are to base your deliberations and decision in this case on the evidence that was admitted in trial only. Anything else that you would like me to say?
I think it is, with all due respect, I think it was way too generous to the state. I believe it's improper. Earlier, when Detective Shepard says things that were improper, the court inserted the word improper into its instruction to the jury. I think the jury should be told that that was improper. And secondly, what I will characterize as what lawyers say is not evidence. I'm lumped into that bag with them. They did something that was improper, and I don't know that we need to do a both sides thing in terms of what lawyers say, in terms of what all of us say is not evidence. That is factual, but the situation that compels this instruction is something the state did, and I think the jury should be told what the state did, again, was improper, and disregard that and place no weight on it.
Your Honor, I don't believe it's improper for the state to be able to argue our theory of the case and have and what occurred out of it. So calling it improper, I don't think is a fair statement of what the state has done. We are allowed to illustrate what we do. It's argument, and they can decide. I don't believe that's how them shots got into the car. Or I do believe it. It's up to them to do that. For me, illustrating it is no less than, like I said, we wheel in a car. I'm sorry.
You're okay.
And pointing at it right here in open court. That's nothing that I would be able to put before Mr. Ravis and Mr. Hooper prior to it starting. And there's nothing that prevents us from doing it because it does not have to be entered into evidence because it is not evidence. It is the state's argument. It is the state's theory of the case.
No one stopped him from his try-on haul. No one stopped him from trying on 50 jackets. Nobody stopped him from putting on that red book bag. No one said that Conley was wearing a red shirt because he's a blood. He might have just been wearing a red shirt because that's what was clean. No, I don't know that anyone inferred he was wearing a red shirt because he was a blood. He didn't really need to have on a red shirt to demonstrate that he was down for the cause with his satchel and his gun. But his little demonstration, that was okay.
I recall I saw the word evidence at some point under the, I don't know if it was under the heading of physical evidence, but it was under the state's own heading of this is evidence.
There was no evidence on that slide.
A complete clown.
It was billed as whatever.
He did a whole try-on
Well,
haul.
they can have a heading on a slide that lists the evidence that says evidence.
But that should not have been listed as evidence.
And it was not one of the slide had no heading.
Okay.
And it's not even illustrative of the state's theory.
Y'all look at Doug. Hey, Doug. Hey, Doug. We're waiting on Nesto's trial. Nesto next. Nexto 2028. We'll be here for trial for Nesto 2028. What do you guys think? Is it Nesto 2027? Is it Nesto 2026, Nesto 2027, Nesto 2028, or Nesto 2030? Which one is it?
Detective Shepard said the shooter was stationary. That was a graphic showing a moving shooter. So it wasn't shown to us, and it's inconsistent with their star witnesses.
Nesto 70 ball.
Okay.
It's wrong on a lot of levels.
Well, it's not wrong on the video because he's showing.
Nesto 3020.
Okay, I understand
Wait,
everyone's frustration.
Nesto
This is a
2030.
situation that could have been handled prior to closing arguments. So, so I'm going to go ahead and give an instruction on this, and motion for mistrial was denied. Anything else that you want to put on the record?
No, Your Honor.
Okay.
I would actually like the instruction read, once the jury comes back in, but then again, the charges as well. I think because of how inflammatory the state just is, I think they need to hear it more than one time, Your Honor.
Okay.
Yeah,
Part of the pattern charge, there's extensive information about in the pattern charge about attorneys' comments not being evidence. Okay, we can take that up after we finish closing. We're ready.
Are you going to read within, is that the instruction, or have you changed it, have you modified it? I'd like to hear the instruction before this one, if I may, Your Honor.
That's fine. Yeah, I think I've said you are not to consider this computer rendering as evidence in the case. I am happy to make it you are not to consider this computer rendering, if that is closer to what you were hoping I would say. I'm not going to say that it was improper. I think under other circumstances that video could have come in.
Under the right process.
Under the right process.
That's the issue.
Well, and yeah, it's hard. There's
Judge Rachel is not a secretary, Arnold. Stop talking to Judge Rachel like she is a secretary over there. That's what we not gonna do. Do you see how he's like, well, it's improper. See, they're kind of forgetting a little bit. Judge Rachel is nice, but she might need to get a little bit more like, excuse me. No.
not rules of evidence about how to do that. Okay.
You don't owe him an explanation, ma'am. You don't. You don't owe him an explanation. Just no is no. Denied.
We're ready for him.
She needs to get nice nasty. She needs to get a little bit more nice nasty. She's already nice, but she's too nice. She needs to get a little. It's denied, sir. It's denied. Don't fucking try me.
Okay, remember you got 11 minutes left. You had 14? Sorry. Let's see, what does man of court reporter have?
He waved back there.
She started off with an hour and 6 minutes. She started off with an hour and 6 minutes left.
All right, the jury. Judge, that kind of court.
Okay, members of the jury, we're about to resume closing arguments. I need to give you this quick instruction. I'm sorry, I'm not looking at you. I need to speak into the microphone for you. A computer rendering of the state's theory of how events in this case might have occurred was played several minutes ago before the break. This was not evidence in the case and was merely an illustration of the state's theory of the case. You are not to consider this computer rendering. The arguments of the attorneys are not evidence. You are to base your deliberations and decision in this case on the evidence that was admitted in trial only. Okay, you can resume your argument.
Thank you, Your Honor. Ladies and gentlemen, I hope you remember in the video where you can see the defendant step up and move along the left side of that car, firing shots into it, and then the evidence indicates there are 8 shots in it, following that pattern that the defendant took as that truck passed by. Then you have the shell casings that you saw from the crime scene tech. Each and every one of them that landed there, that's on that side where that Jeep passed by, 5.56, 5.56. And what did Ms. Van Home tell you? That's consistent with being fired from an AR-15. 8 shots, 7 shell casings, 7 of them are 5.56, and all shot from the same weapon right in the area where this incident occurred. And there was some rumbling about shooting from the car, but there's no evidence. Mr. Reagan's talked about humidity and all of that stuff, but there's no evidence of that. The only evidence is that this defendant walked up to that car and fired off 8 rounds into that car and then caused the death of Superior Attorney. And we talked about the man in the black walking down the yellow, well, all the way to the barricade. He's furthest away. So we know, that's the safe theory, that is not the bullet that went into the back of the car and killed Sequoia. The next guy that's in all black, he's walking along the yellow line, and what's found where he is, a .38 projectile. And then there's none of that back barricade, so we know nobody back there was shooting. We know the only person that was shooting, where these muzzle shots are coming out, is the defendant with his light pants on and his dark shirt and that muzzle flash coming out of his gun, while these 3 people stand out here doing nothing. The scientific evidence, the way that it goes through the back trunk, through the back of the seat, through the outside of the seat, into Sequoia. And like I said, they failed to mention that, so I'm not going to waste my time on it because they know it's foolish to me. 5.56 shell casings, 5.56 projectile, type of weapon that can fire, 5.56 AR-15. The only thing we ain't got to give you is the AR-15, because what did Ms. Van Home tell you? I can look at it and I can test against the weapon and I can determine that whether or not it is a metal weapon or I can eliminate it. If I had it for you, I would give it to you, but I don't. The medical examiner. And I know it was hard looking at these pictures, ladies and gentlemen. I've been doing this a long time, and it's difficult each and every time because nobody should have to look at a baby laid out on the table with a gaping bullet wound in the back of her. But the only person that is responsible for causing that wound back there sits right there. That's on him. Went through her body with so much pressure and so much force, it starts to break apart. We have everything but that gun to be able to tell you this is exactly the gun that did it, because we know all of those 5.56 shell casings came from the exact same weapon. Don't believe me, don't believe the video, don't believe the physical evidence, don't believe the science if you don't want to, ladies. Just believe him. My grandmother always told me, when somebody tell you who they are, believe them. When they show you who they are, believe them. And this defendant has shown us who he is and what he is capable of over and over again. Cobb County with his red bandana, his gang tattoos, his gang language, burn it down. ARs everywhere, every photograph you got with his AR. Pointing it at people, terrorizing people, allowing a community to be locked down because he decided, I'm claiming this as my gang territory. And when he shoots that baby, where he go? Over on edge with his AR-15, still dangling between his legs. But when he shows up to say, oh, that's me, what's conveniently gone? One of those distinctive markers, those twists. He's trying to change, he's trying to hide. But ladies and gentlemen, y'all tell him he cannot hide. He is no longer in the shadows. You see him clearly as who he is. He may sit over there with a suit on, with his haircut, looking nice, but that's not who he is. He is a killer. We saw that in his video at the jail. August 5th, 2025. Just days before this started. This is what he's doing. What is his words? I empower.
I'm playing with him. Yeah.
If I tell you, if I show you, believe it. This is who I am. What he got on him? His gun. Because where he don't go, we don't link up without our sticks. He tells you I had an AR-15. He tells you I was at the barricade. If he don't, even though he don't tell you he shoot, I told you, party of a crime, he is just as guilty. But we know that that is a lie. He shot 8 times into that vehicle. But see, he didn't know the story. He didn't know that Detective Shepard had those videos. He thought I could step out and say, oh, it was me. He didn't realize it. So what did he do? He lied. Mr. Ravis want to talk about lies? That's what that defendant has done. He lied. He got up there. Somebody was hit. Y'all seen that video. Not one person was hit. Not one person hit the ground and jumped up and started shooting. A lie. He said he wasn't shooting. Muzzle shot after muzzle shot. He lied to his attorney because Jackie Patterson only repeated what the defendant told him because he wasn't out there. He hadn't seen no videos. He's a liar and a killer. That's what his autobiography tells you.
She better tell that.
And what does he say? After he sees this, I'm going down the road, I ain't shooting. I ain't even have a gun. Lies. What did he say when they posted the bolo on McKinney? I was out there, bro. Bro ain't even shooting. He's talking about McKinney. Every man out there was shooting at the car. He the only end that walked to the store. It happened at the burnt down windows. Everybody was shooting but McKinney. That includes him. He told y'all he was shooting because everybody out there was shooting. But he's the one that shot and killed Sequoia Turner. Every piece of evidence the state has brought points to this defendant's guilt. The law, the eyewitnesses, the physical evidence, the scientific evidence, the defendant's own actions. And ladies and gentlemen, I implore you to use your common sense. And when you use your common sense, it leads to no other road than the defendant's guilt. Now, we've talked about him for days now. This case is about Sequoia Turner, 8 years old, just riding in the backseat of the car with her mom, coming from celebrating the 4th of July, having fun with her family, her friends, playing with her cousins, watching fireworks for the night. She was having so much fun. What did her mom tell you? She didn't want it to end. I want to go hang out with my cousins. And her mom was trying to make that happen as they headed down University. Nobody knew that day that that was going to be the last time that Charmaine got to go to the nail shop with her baby. That was going to be the last time that Sequoia got to go to a barbecue and a cookout with her grandmother and her cousins. That was going to be the last time that she got to play with fireworks. That was going to be the last time she got to call to play with TikTok, because we know that's what she liked to do, make her TikTok videos. And that's what she was doing back then. And nobody knew it was going to be the last time that she got to call out her mother's name. 8 years old. It is not fair. It is senseless and it is unnecessary. But the defendant wanted to stake his claim. 4th of July is supposed to be about celebrating with your family. For Sequoia Turner's family, forever now. 4th of July is not about celebrating. It's about grief and it's about mourning. This coming November, Sequoia would have turned 13 years old. A milestone for young kids, especially little girls. She will never get to reach that milestone. Mr. Ravis told you that the defendant was making dumb decisions because he was 19. Sequoia will never have an opportunity to make dumb decisions as teenagers do. Her mom told you how she wanted to go to Spelman, and Mr. Ravis told you how his girls got to go to their HBCU. Sequoia will never get to go to Spelman because of this defendant. Hopefully one young girl will get to go because they have a scholarship in her name. Now, Mr. Ravis talked about Ahmaud Arbery. I am from Brunswick, Georgia. I live one neighborhood over from the neighborhood where Ahmaud was killed. I went to church with his aunts. So I know what it feels like to have someone in your community taken because of senseless violence. In his honor, they do a 2.23-mile run because those are the last miles that he got to run that day. For George Floyd, they have a moment of silence for him. 8 minutes and 46 seconds, because those were the last minutes of his life. At some point, hopefully, not just a scholarship, but maybe 8 minutes of silence for Sequoia for the 8 years of her life, or the 8 bullets that flew into that car and took her life. That's what we can do for her in the future. But today is a day that you can give this family the justice that they finally deserve. Mr. Vegas talks about 9 days of rush to judgment and rush to judgment. I tell you, ladies and gentlemen, it has been a slow crawl to justice for Sequoia and her family. They have waited 5 long years, 1 month and 22 days. I ask that you don't make them wait 1 more day, 1 more hour, 1 more minute. Tell this defendant what he already knew when he stood up at that press conference. He is guilty, guilty, guilty of each and every charge on that indictment. Thank you.
I know that's right.
Okay,
Okay.
members of the jury. My instruction to you is going to take about 45 minutes. Would you like to eat before you give the instructions? Okay, we ordered food for you. Just make sure that you don't discuss the case amongst yourselves. Don't do any research. Don't look at your phones. Don't talk about the closing arguments. Just eat lunch, and we'll come back to the jury.
All right, so jury.
Okay, jury. I want to make sure you have a nice lunch.
You can eat quick? Okay, that's fine. You let us know. We're at your beck and call. You think about 15 minutes?
Oh, they're gonna have a quick decision. They're already like, I don't know about you, but it was night. I don't know if I'm gonna see y'all tomorrow. I don't and tomorrow's Friday. It looks like they're gonna have a verdict before 5 o'clock. Okay. We're gonna eat fast, Your Honor. Okay, let's pivot back here real quick because this is what we didn't get to see. Hold on. So this was some of Miss Ma'am's demonstrative. Hold on. Let's see this first because I was trying to be nosy. I went over to the judge's thing. This is some of the things we couldn't see. So she had, this is what I wanted to see. So his actions, his Instagram photos with the multiple guns and gangs. So he basically, the nexus for him to be in a gang is he put his own self in a gang. He placed himself in a gang by his Instagram. Okay. Gang tattoos, gang language, post, burn down Cobb. He put down a post that said burn down Cobb. Defendant points AR-15 at the McCords, shooting into a crowded street on 4th of July in the kids area, or that there were kids also present. Hanging out on Edgewood, where 2 people died that night as well, where I don't know who's responsible for those. He went ahead and changed his appearance for whatever reason, whether it was to hide or just to clean up his appearance, to say, or just to look, to change the optics, because there's nothing wrong with locks, there's nothing wrong with braids, but for whatever reason, he decided to do a different look. So he'd have to articulate why. Changes in appearance, gang activity in jail, so he's still current. Hold on. All right, so let's see. Those were his texts. I ain't shoot her. That's what someone said. I ain't going down the road. I'm going down the road. He said I ain't shoot her. I ain't even have a gun. I was out there, bro. I ain't even shoot every nigga out there was shooting at the car. Every nigga out there was shooting at the car. He was the only nigga that walked to the store. It happened at the burnt down Wendy's. Young Looney. There was a longer one. I felt like when Arnold was bragging on his daughters, that's very nice of you, sir, that you have two daughters that are able to go to an HBCU, that you have two daughters whose daddy is a lawyer, the mother is a flight attendant. It's so nice that you guys are probably live in a nice neighborhood. You know, you may not even live in the neighborhood that you're even trying to defend at this moment. Okay. You may not even live near there. Why are you trying to throw your middle class ship into this? Nobody needs to know that. We're talking about Sequoia, who didn't make it to 3rd grade. Nobody needs to know about your daughter who went to Howard. This lady is working hard to have a scholarship in her daughter's name so that she can send other young women to college in her daughter's name. So her daughter's destiny can be fulfilled through other young women who want to go to college. We don't need to hear about your daughter who's got a father at home who's a lawyer. You know what I'm saying? We didn't need to hear it. You know what I'm saying? That's very nice for you. How very nice for you. And I'm certainly not hating on the middle class. All I'm saying is that was very insensitive to like bring that up, because that's not the set of circumstances that we're currently dealing with. We're dealing with a young girl who didn't make it out of elementary school, who was out splitting time between her mom and her dad and just having a good time on a summer night and hanging with her mom and mom's boyfriend, going back to the house, who had her own set of dreams. What you've done for your kid as a father is not relevant to this closing argument. Did Mr. Conley go to high school and college? Why don't you talk about your client? Did they even mention Mr. Conley made it through 12th grade? He was going to Votech. What was he doing? We don't know shit about him. Did he have a job at Lowe's? Did he have a job at Walmart? What the hell was he doing other than terrorizing the people on 4th of July night? We know about your daughter. We know about your wife. We know about the trial jury, the judge doing the Pledge of Allegiance at a trial. I mean, we know everything but about this client. This Arnold is not good at closing. Whoever deals with Arnold, they don't need to let him close. He's not good closing. Girl, Vietnam War. He's not good at closing. They didn't give him 1 ounce of relatability. He would like to get back to his life. He has aspirations to be an electrician. He has a daughter. Did I miss that? I don't know if he has a kid or not. They never told us, does he have any children? Does he have his family? He's got, nothing. Did he say anything about Mr. Conley? Nothing to humanize him at all. What we do know about Mr. Conley is that he killed an 8-year-old. That's what the prosecution is alleging. He terrorized Charmaine Turner. He killed Charmaine Turner's daughter. Mr. Omar is very guilty. He just wanted to get his girlfriend and his baby, the little girl, home. The McCords are still shooketh. Okay? The McCords are still shooketh from 5 years ago. That's what we know. We know that Julian is still active and having a good damn time over at Rice Street. He's been in trouble over at Rice Street. He's still in a gang over at Rice Street. He's got contraband phones with confidential files in it over at Rice Street. He's a known gangbanger. What else do we know? It's like, damn. He didn't put any effort into, we don't know anything about him. His parents are eagerly awaiting for him to come home. His mother is waiting. If he has kids, the kids are waiting. He didn't tell us about his goals. We have, he's got this program, that program ready to accept him. He's ready to go back to his normal life. Blah, 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 blah. He didn't tell us shit. The closing lines for me was that she emphasized the red blood of the victim that mattered. I'm paraphrasing, but the way she phrased it was powerful. Yeah, she was very, very, very good. But as far as, look, we know that the prosecution has a compelling argument. I mean, I just don't want to, you know what I mean? Like their argument is compelling. I was, it just seems like we do cover a lot of cases where the prosecution prevails. And sometimes there are cases that we watch and the defendant is innocent. Like I would never, like that Michael Jackson Bolanos case. I don't know if any of you saw that, but that case was so good in Detroit. The guy, they were trying to put murder on him. And I talk about it all the time because it was the testimony. I mean, they had some circumstantial evidence, but it was the testimony that people actually sat, they came, they told the truth. And when you use your common sense, it's like, well, that wasn't him. And I mean, he was exonerated. The only thing was that he was found guilty because he did lie to a police officer. And I think they were kind of mad because I feel like they thought that they had their man, or they had staked this case on him, and the case fell apart for the prosecution. But the witnesses came, they told the truth, and people with good common sense could not find their way to a guilty verdict because the man was not guilty. He was guilty of lying. He was guilty of being at the wrong place at the wrong time. And he could have really came close to a murder conviction, but he was not guilty. He was guilty of lying, and that's why his behind is in jail. And he's going to get out sooner than later because maybe they gave him 18 months. He may already be out. If he's not out, he'll be out soon. But that was a good case. I didn't know anything about it until I started watching it, and it was like common sense. He's innocent. Now, that's not what this case is giving. This case, you cannot see any of those frames without seeing Julian is there. And based on what they charged him with, he is guilty. He's guilty of a lot of the things that they have accused him of outside of even the shooting aspect. He's guilty of about 4 or 5 things on his charging document. Anyway, my thing is with the defense, his lawyers spent no time trying to humanize him other than calling him a stupid gangbanger kid. That's what his lawyer, and maybe that's what he is. Maybe that's all he is a stupid gangbanging kid. But I would not be happy with a lawyer who's supposed to be defending me using that as an excuse as to why I'm innocent. If I'm innocent, I'm innocent. Don't call me no damn stupid gangbanging kid. You know what I'm saying? I don't think that Hoover and Goofy Arnold were good at all. Hoover seems to have a talent for trying to find a technicality, But just like the judge said, close, but not quite. Okay. She said, yeah, you're close, but not quite. And Miss Brooks, was it Aisha Brooks? Miss Brooks, the lady with the her vintage suits, baby, no. Mm-mm. They were about as bad as the team that helped Donna Adelson get her LWAP. Okay. You say he's selling LWAP? Stop it. Okay, let's go back and see. Did they eat their sandwiches? Are they done? They got the camera off. Hold on. Let me go over to the judge's desk. The judge still has her camera on. Hold on. Is that Hoover sitting over there? Look how the defense has their camera. They got their camera at the ceiling. Sean Hoover probably got a tissue over his camera. Oh, you see Arnold sitting right there? Look, there's Arnold right here. You see Arnold? There's Arnold. There's Abate, Adam, Miss Thang with the red shoes. I don't know her name. And Mr. X. So you trying to, Mr. What did he ask yesterday? So you trying to tell me you was trying to find out who shot the gun, but you was standing right there? Is that what you're saying? Mr. Burgundy suit yesterday? Hey guys, they only have one witness. Can I take them? I'm gonna play nice nasty, okay? I'm gonna take her, okay? Y'all, we're on here all day again. You says Gary with the T. Oh, that's Doug right there. Right there. Ooh.
All right, for the jury.
Ooh, Yuri said we don't need no time at all. They said we don't need no time. Okay, but look at Fox. Fox is not serious. The guy from Fox must be on break. Y'all, can I tell you guys a little secret? It's a secret, but not a secret. It's not a secret for you guys because you guys are watching. So is the judge at the bench?
All right, members of the jury, I know nobody wants to sit here 45 minutes of instructions, but at least you're not starving to death now, so. Okay, and I'm going to remind you that you're welcome to take notes. Can you all hear me well? Oh, so. Here, let me scoot closer to the microphone. Remember that we're going to send out written copies of the charge, so don't feel that you have to take everything down. You're welcome to if it helps you listen. Okay? You are now considering the case of State of Georgia versus Julian Conley. The grand jury has charged the defendant with 19 offenses: murder, 2 counts of felony murder, 5 counts of aggravated assault, criminal damage to property, 2 counts of possession of a firearm during the commission of a felony, and 8 counts of violation of the Street Gang Terrorism and Prevention Act. The indictment states the exact offenses charged. You will have it with you during your deliberations. Please read it carefully. This indictment was filed with the clerk on August 25th, 2025. The defendant has entered a plea of not guilty to this indictment. The indictment and the plea form the issue that you are to decide. Neither the indictment nor the plea of not guilty should be considered as evidence. A defendant is presumed to be innocent until proven guilty. The defendant enters upon the trial of this case with a presumption of innocence in his favor. This presumption remains with the defendant until it is overcome by the state with evidence that is sufficient to convince you beyond a reasonable doubt that the defendant is guilty of the offense charged. No person shall be convicted of any crime unless and until each element of the crime is proven beyond a reasonable doubt. The burden of proof rests upon the state to prove every material allegation of the indictment and every essential element of the crime charged beyond a reasonable doubt. There is no burden of proof upon the defendant whatsoever, and the burden never shifts to the defendant to introduce evidence or to prove innocence. However, the state is not required to prove the guilt of the accused beyond all doubt or to a mathematical certainty. A reasonable doubt means just what it says. A reasonable doubt is the doubt of a fair-minded, impartial juror honestly seeking the truth. A reasonable doubt is a doubt based upon common sense and reason. It does not mean a vague or arbitrary doubt, but is a doubt for which a reason can be given, arising from consideration of the evidence, a lack of evidence, or a conflict in the evidence. After giving consideration to all of the facts and circumstances of this case, if your minds are wavering, unsettled, or unsatisfied, then that is a doubt of the law, and you must acquit the defendant. But if that doubt does not exist in your minds as to the guilt of the accused, then you would be authorized to convict the defendant. If the state fails to prove the defendant's guilt beyond a reasonable doubt, it would be your duty to acquit the defendant. Facts and circumstances that merely place upon the defendant a grave suspicion of the crime charged or that merely raise a speculation or conjecture of the defendant's guilt are not sufficient to authorize conviction of the defendant. Members of the jury, it is my duty and responsibility to determine the law that applies to this case and to instruct you on that law. You are bound by these instructions. It is your responsibility to determine the facts of this case from all of the evidence presented. Then you must apply the law I give you in the charge to the facts as you find them to be. Your oath requires that you will decide this case based upon the evidence. Evidence is the means by which any fact that is put in issue is established or disproved. Evidence includes all of the testimony of the witnesses and any exhibits admitted during the trial. Evidence does not include the indictment, the plea of not guilty, opening or closing remarks of the attorneys, or questions asked by the attorneys. Evidence may be either direct or circumstantial or both. In considering the evidence, you may use reasoning and common sense to make deductions and reach conclusions. You should not be concerned about whether the evidence is direct or circumstantial. Direct evidence is the testimony of a person who asserts that he or she has actual knowledge of a fact, such as an eyewitness personally observing or otherwise witnessing a fact. Circumstantial evidence is proof of a set of facts and circumstances that tend to prove or disprove another fact by inference. That is, by consistency with such fact or elimination of other facts. There is no legal difference in the weight you may give to either direct or circumstantial evidence. You will be authorized to convict only if the evidence, whether direct, circumstantial, or both, excludes all reasonable theories of innocence and proves the guilt of the accused beyond a reasonable doubt. The jury must determine the credibility of the witnesses. In deciding this, you may consider all of the facts and circumstances of the case, including the witness's manner of testifying, their means and opportunity of knowing the facts about which they testify, the nature of the facts about which they testify, the probability or improbability of their testimony, their interest or lack of interest in the outcome of the case, and their personal credibility as you observe it. The credibility of a witness may be attacked by disproving the facts to which the witness testified. Testimony has been given in this case by certain witnesses who are termed experts. Expert witnesses are those who, because of their training and experience, possess knowledge in a particular field that is not common knowledge or known to the average citizen. The law permits expert witnesses to give their opinions based upon that training and experience. You are not required to accept the testimony of any witnesses, expert or otherwise. Testimony of an expert, like that of all witnesses, is to be given only such weight and credit as you think it is properly entitled to receive. In determining the credibility of a witness, you may consider, where applicable, evidence offered to attack or challenge the witness's credibility. The testimony of a single witness, if believed, is sufficient to establish a fact. Generally, there is no legal requirement of corroboration of a witness, provided you find the evidence to be sufficient. A defendant in a criminal case may take the stand and testify, and be examined and cross-examined as any other witness. However, no defendant has to present any evidence nor testify. If a defendant chooses not to testify, you may not consider that in any way in making your decision. Identity is a question of fact for you to determine. Your determination of identity is dependent upon the credibility of the witness or witnesses offered for this purpose. You should consider all of the factors previously charged to you regarding the credibility of witnesses. Some, but not all, of the factors you may consider in assessing reliability of identification are the opportunity of the witness to view the alleged perpetrator at the time of the alleged incident, the witness's degree of attention toward the alleged perpetrator at the time of the alleged incident, the possibility of mistaken identity, whether the witness's identification may have been influenced by factors other than the view that the witness claimed to have, whether the witness on any prior occasion did not identify the defendant in this case as the alleged perpetrator, and the length of time between the crime and the out-of-court identification. It is for you to say whether under the evidence in this case, the testimony of the witnesses, and the facts and circumstances of the case sufficiently identify this defendant beyond a reasonable doubt as the perpetrator of the alleged crime, or that the defendant was a party to it. It is not necessary that the defendant show that another person committed the alleged offense. If you do not believe that the defendant has been sufficiently identified as the person who committed the alleged crime or was a party to it, or if you have any reasonable doubt about such, then it would be your duty to acquit the defendant. The burden of proof rests upon the state to prove beyond a reasonable doubt the identity of this defendant as the person who committed the crime alleged in this bill of indictment. This defendant is charged with crimes against the laws of this state. A crime is a violation of a statute of this state in which there is a joint operation of an act and an intention. Intent is an essential element of any crime and must be proved by the state beyond a reasonable doubt. Intent may be shown in many ways, provided you, the jury, believe that it existed from the proven facts before you. It may be inferred from the proven circumstances or by acts and conduct, or it may be, in your discretion, inferred when it is the natural and necessary consequence of the act. Whether or not you draw such an inference is a matter solely within your discretion. Criminal intent does not mean an intention to violate the law or to violate a penal statute, but means simply the intention to commit the act that is prohibited by a statute. This defendant will not be presumed to have acted with criminal intent, but you may find such intention or the absence of it upon a consideration of words, conduct, demeanor, motive, and other circumstances connected with the act for which the accused is being prosecuted. Every party to a crime may be charged with and convicted of commission of the crime. A person is a party to a crime only if that person directly commits the crime, intentionally helps in the commission of the crime, intentionally advises, encourages, hires, counsels, or procures another to commit the crime, or intentionally causes some other person to commit the crime under such circumstances that the other person is not guilty of any crime either in fact or because of legal incapacity. Any party to a crime who did not directly commit the crime may be prosecuted for the commission of the crime upon proof that the crime was committed and that the person was a party to it, even though the person alleged to have directly committed the crime has not been prosecuted or convicted, has been convicted of a different crime or degree of crime, is not amenable to justice, or has been acquitted. Knowledge on the part of the defendant that the crimes charged in the indictment were being committed and that the defendant knowingly and intentionally participated in or helped in the commission of such crimes must be proved by the state beyond a reasonable doubt. If you find from the evidence in this case that the defendant had no knowledge that a crime was being committed, or that the defendant did not knowingly and intentionally commit, participate, or help in the commission of, and was not a conspirator in the alleged offenses, then it would be your duty to acquit the defendant. On the other hand, should you find beyond a reasonable doubt that the defendant had knowledge that the crimes charged in the indictment were being committed, and that the defendant knowingly and intentionally participated or helped in the commission of them, then you would be authorized to convict the defendant. A jury is not authorized to find a person who was merely present at the scene of a commission of a crime at the time of its perpetration guilty of, consent in, and concurrence in the commission of the crime, unless the evidence shows beyond a reasonable doubt that such person committed the alleged crime, helped in the actual perpetration of the crime, or participated in the criminal endeavor. A jury is not authorized to find a person who was merely associated with other persons involved in the commission of a crime guilty of consent in or concurrence in the commission of the crime, unless the evidence shows beyond a reasonable doubt that such person helped in the actual perpetration of the crime or participated in the criminal endeavor. The law provides that criminal action shall be tried in the county in which the crime was committed. In a prosecution in any case in which it cannot be determined in what county the crime was committed, venue is proper and may be proved in any county in which the evidence shows beyond a reasonable doubt that it might have been committed. Venue, that is, that the crime was committed in Fulton County, is a jurisdictional fact that must be proved by the state beyond a reasonable doubt as to each crime charged in the indictment, just as any element of the offenses. Venue must be proved by direct, circumstantial evidence, or both. The defendant is charged in count 1 with murder. For malice murder, the state must prove that the defendant caused the death of another person unlawfully and with malice aforethought. The killing must have been done with malice to be murder. Malice, as the term is used here, is not necessarily ill will or hatred. Rather, it is the unlawful intent to kill. You may find malice when the circumstances show that the defendant acted with deliberate intention to unlawfully take the life of another person. You may also find malice when there does not appear to be a significant provocation, and all of the circumstances of the killing show an abandoned and malignant heart. The state does not have to prove premeditation to prove murder. If a killing is done with malice, it is murder regardless of how briefly the malicious intent existed. No specific length of time is required for malice to arise in the defendant's mind. Malice may be formed in a moment, and instantly a fatal wound may be inflicted. If malice was in the defendant's mind at the time of the act or killing and it moved the defendant to do it, that is enough for the killing to be murder. The state does not have to prove motive to prove murder. Any evidence of motive has been admitted for your use in determining the defendant's state of mind at the time of the killing. The defendant is charged in counts 2 and 3 with felony murder. For felony murder, the state must prove that the defendant caused the death of another person by committing a felony. The state does not have to show that the defendant acted with malice to prove felony murder. Aggravated assault with a deadly weapon and criminal damage to property in the first degree are both felonies, which I will define for you shortly. You may find the defendant guilty of felony murder as alleged in count 2 if you believe that he caused the death of another person by committing the felony of aggravated assault with a deadly weapon, regardless of whether he intended the death to occur. There must be some causal connection between the felony and the death. You may find the defendant guilty of felony murder as alleged in count 3 if you believe that he caused the death of another person by committing the felony of criminal damage to property in the first degree, regardless of whether he intended the death to occur. There must be some causal connection between the felony and the death. Felony murder is not established simply because the death occurred at the same time as or shortly after the felony was attempted or committed. The felony must have directly caused the death or played a substantial and necessary part in causing the death, regardless of when the death ultimately occurred. The defendant is charged in counts 4, 5, 6, 13, and 14 with aggravated assault with a deadly weapon. For aggravated assault, the state must prove that the defendant assaulted another person with a deadly weapon. To prove assault, the state does not have to prove that the other person was actually injured. However, the state must prove that the defendant attempted to cause a violent injury to the person. A firearm, when used in the way a firearm is ordinarily used, is a deadly weapon. The defendant is charged in count 7 with criminal damage to property in the first degree. For criminal damage to property in the first degree, the state must prove that the defendant, knowingly and without authority, interfered with any property so as to endanger human life. The defendant is charged in counts 8 and 15 with possession of a firearm during the commission of a felony. For possession of a firearm during the commission of a felony, the state must prove that the defendant had a firearm on his person or within arm's reach of his person while committing a felony, which is a crime against or involving another person. Murder, felony murder, aggravated assault with a deadly weapon, and criminal damage to property in the first degree are referenced in count 8. Each of those offenses are felonies which have been defined in this charge. Aggravated assault with a deadly weapon is referenced in count 15. That offense is a felony and has been defined in this charge. For purposes of this offense, a firearm includes any handgun or rifle. The defendant is charged in counts 9, 10, 11, 12, 17, 18, 19, and 20 with the offense of violation of the Street Gang Terrorism and Prevention Act, also referred to as the Gang Act. For a violation of Subpart A of the Gang Act, as alleged in counts 9 and 17, the state must prove that there is a criminal street gang, that the defendant is associated with that criminal street gang, that the defendant participated in criminal gang activity, and that there was a nexus between the crime that was committed and the gang, i.e., that the crime was committed to further the interests of the gang. For violation of subsection B of the Gang Act, as alleged in counts 10 and 18, the state must prove that there is a criminal street gang, and that the defendant is associated with that criminal street gang, that the defendant participated in criminal gang activity, and that the defendant committed criminal street gang activity with the intent to maintain or increase his status within the criminal street gang. For violation of subsection E of the Gang Act, as alleged in counts 11, 12, 19, and 20, the state must prove that there is a criminal street gang, that the defendant encouraged another to participate in criminal gang activity, and that the defendant was at the time an associate of that criminal street gang. For purposes of the Gang Act, the term participate can, but does not have to be defined as to take part in something and or to share in something. Criminal street gang means any organization, association, or group of 3 or more persons associated in fact, whether formal or informal, which engages in criminal gang activity. The term criminal street gang shall not include 3 or more persons associated in fact, whether formal or informal, who are not engaged in criminal gang activity. The existence of a criminal street gang may be established by evidence of a common name or common identifying signs, symbols, tattoos, graffiti, or attire, or other distinguishing characteristics, including, but not limited to, common activities, customs, or behaviors. Whether a criminal street gang exists in this case is for you, the jury, to decide. Criminal gang activity means, among other things not relevant to this case, the commission, attempted commission, conspiracy to commit, or solicitation, coercion, or intimidation of another person to commit any criminal offense that involves violence, possession of a weapon, or use of a weapon. For purposes of the counts charging a violation of the Gang Act, murder, felony murder, aggravated assault with a deadly weapon, criminal damage to property, and possession of a firearm during the commission of a felony constitute criminal gang activity. The commission of any offense that would constitute criminal gang activity by any member or associate of an alleged criminal gang may be considered by you to determine whether the state has proven beyond a reasonable doubt the existence of the criminal street gang and criminal gang activity. Presence, companionship, and conduct before and after the commission of the alleged offense may be considered by you in determining whether or not such circumstances, if any, give rise to an inference of the existence of a conspiracy. A conspiracy is an agreement between two or more persons to do an unlawful act, and the existence of a conspiracy may be established by proof of acts and conduct, as well as by proof of an express agreement. When persons associate themselves in an unlawful enterprise, any act done by the party to the conspiracy to further the unlawful enterprise is considered to be the act of all the co-conspirators. However, each person is responsible for the acts of others only insofar as such acts are naturally or necessarily done to further the conspiracy. Whether or not a conspiracy exists in this case is a matter solely for you to determine. The verdict form lists all of the counts and offenses you will be considering. You will consider each offense listed. If, after considering the testimony and evidence presented to you, together with the charge of the court, you should find and believe beyond a reasonable doubt that the defendant in Fulton County, Georgia, did on or about the date alleged commit an offense or offenses charged as alleged, you would be authorized to find the defendant guilty of such offense or offenses. In that event, the form of your verdict for such offense or offenses would be, we, the jury, find the defendant guilty, and you should place an X or a check mark on the blank next to the word guilty for any such offense or offenses. If you do not believe that the defendant is guilty of an offense or offenses, or if you have any reasonable doubt as to the defendant's guilt, then it would be your duty to acquit the defendant on that count or those counts. In that event, the form of your verdict would be, we, the jury, find the defendant not guilty, and you should place an X or check mark on the blank next to the word not guilty for any such offense or offenses. One of your first duties in the jury room will be to choose one of you to be the foreperson. The foreperson will manage your deliberations and will sign the verdict to which all 12 of you freely and voluntarily agree. You should start your deliberations with an open mind, talk with each other, and consider each other's views. Each of you must decide this case for yourself, but you should do so only after discussing and considering the case with your fellow jurors. Don't hesitate to change an opinion if you are convinced that it is wrong. However, you should never give up an honest opinion to be congenial or to reach a verdict solely because of the opinions of other jurors. During your deliberations, you must not communicate with anyone other than your fellow jurors about this case. You are also not permitted to conduct any research about this case, including persons, places, or legal concepts mentioned during the trial. These rules apply not only to in-person communication, but also to communication or research using cell phones, text messaging, websites, or social media of any kind. Whatever your verdict is, it must be unanimous. That is, agreed to by all. The verdict must be in writing and signed by one of your members as foreperson, dated and returned to be published in open court. Your verdict should be a true verdict based upon your opinion of the evidence according to the laws given you in this charge. You are not to show favor or sympathy to one party or the other. It is your duty to consider the facts objectively without favor, affection, or sympathy to either party. In deciding this case, you should not be influenced by sympathy or prejudice because of race, creed, color, religion, national origin, sexual preference, local or remote residence, or economic status for or against either party. By no ruling or comment that the court has made during the progress of this trial has the court intended to express any opinion upon the facts of this case, upon the credibility of the witnesses, upon the evidence, or upon the guilt or innocence of the defendant. You are only concerned with whether the defendant is guilty or not guilty. You are not to concern yourselves with punishment. There are 2 alternate jurors, and we can only allow 12 to deliberate the case. The deputies will show the alternate jurors to a separate location. That's jurors 33 and 35. You may now retire to the jury room. You may elect a foreperson, but do not begin your deliberations until you receive the indictment and any evidence that has been admitted in the case. Any jury communication to the court must be in writing, signed by the foreperson. So that means questions. Now, I know that you have requested to actually perform your deliberations in a different location, and that's fine. But if you want to see evidence that you don't receive in the back, which will be much of the evidence, you're going to have to come back down here to see it. So just so you know that in open court. If you have any questions or you want to request evidence, you just send us a note and have your foreperson sign it. All right, will you go ahead and step out? Okay. Do you guys want to take a look at whether you agree on what goes back?
Yes, Your Honor, but before we go forward, on behalf of Mr. Conley, we'd like to review all objections that have been since last week.
Okay.
Thank you. Here.
And just let me know if I need to break a tie on something. Otherwise, if you agree, it'll go back.
Okay, so this is the judge's feed. Fox cut everybody out, and then
Commits the crime.
Fox cut everybody out, but then came back
There
on
must be some
some,
causal connection between participants.
I don't know. They
Correct.
cut it, and
We'll
then
find out.
they cut the feed now. So they are on break. Guys, this is what I'm gonna do. We gonna cut the feed because we don't know how long they're gonna be gone. I don't think they're gonna be gone long. So I'm just gonna preface it with please forgive me because I got to go to a tennis match. But I'm going to be watching, and when they go live with the verdict, I will call y'all back. If I'm outside, you'll know why, but I will call y'all back. Okay, I will call y'all back. I promise. I'm gonna be I got my headset. My phone is charging. I got my iPad. I've got my phone, and I'm getting ready to get the mobile studio popping. Okay, I will be in the mobile studio because I mean it could be like 2 hours. It might not even be that long. They might be out for like a hot minute. Um, I feel like, girl, I'm gonna be calling y'all from the highway. You guys already know there is no reasonable doubt here. No. It's either you believe that they let me tell you something. If you go to the chat room on Fox right now, baby, I don't know what these people watched. It was funny. Blabbermouth. You guys all knew. If you're new here, you don't know who Blabbermouth is, don't worry about it. There's a certain thank you, Brother Brown. I apologize. I didn't even see these come through. Thank you, y'all. Thank you. And thank you for supporting this broadcast. Okay. Thank you very much. I appreciate that. Blabbermouth, why did Blabbermouth put in a rule 22? I think yesterday, either yesterday or the 22nd. Interesting fun fact. All verifiable. I wouldn't just say that if it wasn't true. It's in the record. Any of you guys who know how to look up the record, look up the record. Ma'am all of a sudden requested a rule 22, but you've gone to go be seen, have your ponytail seen in New York. Yes. Can you believe it? Maybe because she had somebody on live to be able to explain it. You know what I mean? Like what was actually, because if you can't tell the story, if you have somebody else who's telling the story, then you can tell the story. So yeah, somebody right before the trial ended went and put in for rule 22. I died last night. Mm-hmm. Why would she do that if she was going out of town to New York? I don't know that lady. I don't know her. I'm not friends with her. I can't tell you. But if you want to go check, you can see. Apostles like, girl. Yes. Yes. Go look. It's right there in Odyssey. I don't want to be hold on, let me be, I look, because I said it, I can always back up a receipt. Okay? Hold on. Just in case someone out there is like, no. And look, I don't own these case, like, you know what I'm saying? Anybody can talk about a case, right? Anybody can. It's just interesting. Like, ma'am, this has been going on for over a week. Why all of a sudden do you want that's weird, but to each his own. Have at it, right? But then you get it and then you take off. So you're not even really dedicated. You were probably just looking for content. You were looking for content. Okay, hold on. It's a murder case. Can y'all see? 22nd. When was the 22nd, guys? I guess after we binge watched it, maybe it was looking like, oh, this is kind of an interesting case. Oops, my bad. We binge watched it the whole weekend. And it's on Fox. What's the point? I mean, you don't really need a Rule 22. It's on the TV, and the judge has actually got her Zoom up. You know what I'm saying? Like, hold on. Courtroom. She wanted to be in the courtroom yesterday. Did she go yesterday? Was she there yesterday? Thirst with no glass. No vessel. There's no vessel. Oh my God. I was like, okay, well, interesting. I was like, you gotta be kidding me. Girl, I was looking to see if they had posted anything, filed anything on this. As you can see, they did file a couple of documents last night. And I was like, and what is this? Hold on. They filed an amended witness list. Okay. Well, we saw it. Okay, guys, let me do this. Let me shut this down. What I can do, I wonder if she took her live down. Do you see? Oh, you guys can't see it. She just shut down her live. Okay. Judge Rachel took it down. And then they're over here. Okay. All right. We will confer later. Also, let me give you guys a little bit of an update too, on top of everything, which I haven't had a chance to file my story yet, but your boy, the very, very bad Jarvis Butts, y'all, he just got some more charges. Okay. He's got more charges. I mean, my God, he's got, how many cases does he have now? He might be up to damn 21. Okay. He just has another case with another 3 charges. Okay. Hold on a second. Let me see if I can find it. I had it on my screen, but not anymore. He just got charged with another case. Let me go over here. Can y'all see? No. I'll put up a report later, but let me show you guys. Yesterday, 3 more. Criminal sexual assault, person under 13, first degree, second degree, criminal sexual assault, person under 13, criminal sexual assault, second offense notice. This is for a situation that happened in 2021. Tina Ripley on the case, and he was charged with this yesterday. I really think he is up to like 21. He's up to like 21. There's a whole nother set of circumstances, y'all. This guy's never getting out, which is, I'm sure, fine with a lot of people. But let me get my research in. I've got all the case information. I just don't know too much about it. He hasn't been arraigned yet. This literally just happened yesterday. That could be another reason. I mean, I almost think as prolific of a child abuser as this man has been a sexual offender, there's no way to kind of capture everything. I don't know if this is a reason why they postponed his case, the case that was supposed to start next month. that's now starting in February. It's not just Nazaya, it's other women as well, other young women, children. I don't know that they would be pushing it back to try to capture all of his bad deeds, all of these crimes. It's possible that they knew these were coming, but I think we've heard on numerous occasions more is coming. Um, he seems like he has been a prolific um child abuser, sex offender, rapist, whatever you want to call this guy, whatever fits. Because he is a convicted one. He has been a convicted um sex offender already. So these new allegations are nothing new. He's already been convicted of this type of a crime. He's a predator. He's already doing a parole violation for a gun charge. The man is a life career criminal. With the amount of things that he currently has pending, really and truly, if he's found guilty on one thing, he's going to be in jail for the rest of his prison for the rest of his life. So he's got so much going on. He's pretty much done. He's done. So, but yeah, he just caught another case. So, you guys are hearing this first over here on this channel. I hadn't talked about it yet, so I don't know if anyone else is talking about it yet, but these charges just came up yesterday, so you might hear about it. As soon as I find out a little bit more, I'll get back with you and let you guys know like what's actually going on. But he's absolutely gross. And thankfully, there's a climate now where these girls are coming out from the bushes and can tell their story, and he's getting his charges accordingly because he has been absolutely disgusting out here. And it seems like the victims are coming, they're telling their stories, and the charges are being filed, which is a good thing. So um it's kind of crazy to think like, my God, it's like how many more people are going to come out the bushes? Like, this is terrible. He has been out here just doing whatever he wanted to do. Unbelievable, right? Okay, guys, we'll talk more about it. Another thing too, late yesterday, Darnell Jones had court too. The story of the father and the murder situation with Kamani Latig. He had court yesterday. I didn't run it. Number one, we were busy with this. Number two, it was a continuation of last week, so it wasn't really anything earth-shattering to report. The judge is having to consider whether he's going to allow those CPS records to come in. So I'm going to probably do like a Jarvis and Darnell, since their stories are kind of parallel. We're both dealing in the death of a 13-year-old. So yeah, I might do one report just to give an update on what I know so far. But Darnell was in court again yesterday for about 45 minutes, and they did their argument on the CPS records, and the judge is going to have to think about it. But CPS was like, we're not giving you free reign just to look through CPS records to find your defense. That's basically what they said. If you want something, we'll turn it over to the court. The court will take custody of it. They'll let you use it how you need to use it, and then it's going to come back to us. Basically, they want to be able to preserve their records, and they're not going to have the records, they're private, right? And the reason why also is because it does contain records of people reporting people and stuff like that. And they want their system to be open for people to feel like they can report something if they need to and not have their names made public. They're committed to that type of thing. So that was pretty interesting to hear. But anyway, I'll give you guys a further report between today and tomorrow. But right now we'll just wait to hear back on some I bet you, I almost feel like when I get in the car, let me tell you something. Look at this. There are people over here saying that they're going to file complaints on the judge because they allowed that video in. He was smirking because he knew he solved one of them ones. I'm filing a complaint on the judge today. Abati knew the video was coming in. We sick in the head, old woman and everything on here screaming he didn't do it. That's why they split the timing on closing arguments. Prove it. Where's the evidence? They put it right in your face. Girl, they're arguing about if they did it or not. Somebody said that they're over there going to file a complaint against the judge. Girl, a mess. Anyway, all right, guys, let me let y'all go. As soon as they come back with the verdict, I'll let you guys know. If you guys see it ahead of time and I'm behind on bringing the verdict back to you guys, please don't put any spoilers. If you put a spoiler in here, it's going to be fine. But when we come back live, if it's after the if it's after the verdict has been read, please don't spoil. Like we'll know. You know what I mean? We'll know. So just no spoilers. You think he's gonna have a lot of pen pals? He might. You never know. Anyway, okay, you guys. I'll see you later. Take care, okay? Have a good afternoon. I'll be back as soon as I hear the verdict, okay? Bye, guys. I bet you as soon as I get in the car, it's gonna be like, oh God. Okay, I'll see you later.